My name is Joel Ard. I'm a solo practitioner here in Washington State, and I've had the privilege of representing local firearms dealers, ordinary citizens, and organizations like the Second Amendment Foundation and NRA in challenging state encroachment on Second Amendment rights. I appreciate the opportunity to speak at this conference addressing when, and more importantly, how states can try to control the federal government. I'm also going to touch a little bit on how local governments, cities and counties, can try to exercise that same kind of control over state gun laws, because that's an issue of increasing importance in rural counties within West Coast states. I'll begin with a brief overview of the governing principles, early Supreme Court case that began highlighting this issue, cover some more recent implementations of that principle, and again, because it's dear to my heart, address some ways that Western states have seen tension between state and local enforcement. So remember these basic governing principles when we consider how state government can control the federal government, or how a local government, city or county, can control the state. For those of us who have a working knowledge of government, the level that we used to call high school civics, both ideas should seem a little bit wrong at first blush. After all, federal law is supreme, trumps any state law to the contrary on the same subject. If one of our states passed a law saying their residents didn't have to pay federal income tax, the IRS won't care and will win. The theoretical limit to federal supremacy is that the federal government is supposed to only act within a limited sphere. States, by contrast, have a subordinate role in areas where the federal government has spoken, but plenary police power. They can act in nearly every sphere, including areas where the feds also act, as long as they don't contradict the national government. States can't issue currency or declare war, but that's the limits. But because there's so much actual practical overlap with state authority in the modern iteration of the federal government, the most important breaking point is who pays the bills. The federal government can't force state actors to enforce federal law, but they can condition federal funds on cooperation and assistance. The extent of the federal ability to condition funds on cooperation is in flux. And then finally, touching on the added topic I'm introducing, local control or rejection of state authority, state law largely determines the extent to which prosecutors and sheriffs are independent of statewide officials. In my own state of Washington, for example, each county elects its prosecutor, separately elects its sheriff. The counties are also responsible for a lot of the funding of those offices, giving the local head of law enforcement and local head of prosecution significant leeway in decisions about emphasis. So this all began with the Brady Bill. Then we've got a big Obamacare case and sanctuary cities that really informed the discussion. In 1993, Clinton signed the Brady Bill that implemented, among other things, a background check, but it required each state to designate the chief law enforcement officer of the buyer's residence to perform the check. Jay Prince was designated as that because he's a county sheriff in Montana, and he sued, saying the federal government could not commandeer state officials to do the feds' jobs, and the Supreme Court agreed. But of course, both before and after the law suited Prince, local government does do a lot of federal work, because in most instances, the federal government gives the state money and conditions the receipt on the state implementing or executing whatever policy the feds prefer. The best example of this is the 21-year-old drinking age. The condition of states receiving federal highway funds is that state law have a 21-year-old drinking age. Now, this leads us to the Obamacare challenges. In a gross abbreviation of some complicated arguments, part of Obamacare included an expansion of Medicaid. That's a part federal, part state program. It takes up a big chunk of state budgets. This was going to expand the program. You got more money if you opted in, but they took away all your Medicaid money if you opted out. A group of states sued, saying the conditions on opting out were so onerous as to make the expansion essentially not a choice. Given the onerous conditions and the vast percentage of the state budget at issue, they said, the spending conditions exceeded federal power, and the Supreme Court agreed. So this broke some new legal ground that will undoubtedly be explored in future cases, including, no doubt, Second Amendment sanctuary type cases. So sanctuaries. We all know about immigration sanctuary cities and states, state and local laws that forbid local law enforcement from cooperating with federal law enforcement, immigrations and customs, to deport illegal aliens. But that's the basic principle of Prince and the Brady Bill case. Local law enforcement can cooperate if it wants to, but it doesn't have to. In the last administration, the feds started trying to cut off funds from the cities and states. The principle of the Obamacare case then came to the fore, when states tried to argue that the condition cutting off the funds was too onerous, among other things. So there's the basic civic standards, some relevant Supreme Court history, but the tension between state and federal enforcement priorities becomes really obvious with one more important fact. there are about 18,000 separate law enforcement agencies in the United States. Together, they employ 700,000 uniformed officers. Only 100,000 of those are federal, of which only 60%, are responsible for criminal investigation and police and patrol work. The other 40% are inspectors, they're corrections officers, they're court security, and those 60,000 criminal investigative folks have specific focuses other than firearms laws, even if, for example, drug smuggling or human smuggling often coincides with gun crimes. So the enforcement of federal law is very often done in cooperation with local law enforcement, just from the sheer weight of numbers. So the first way state and local government can control the feds is the same way that California led the way with its opposition to immigration enforcement, be a sanctuary state. And of course, we're hearing more and more about Second Amendment sanctuary states. The federal government can't co-opt state and local law enforcement to compel them to enforce federal law. It can try to bribe states and localities, but that has two limits. The first one, from the Obamacare context, is a hazy limit, tested really only once. Obamacare is really the only statement of the Supreme Court on spending conditions going too far. In that instance, adopt the expansion or lose all your Medicaid funds? That was too much. Can Congress therefore condition tomorrow's funding grant to state law enforcement on them agreeing to enforce federal gun laws? Well, if it's a fraction of the total, a portion closely related to those gun issues, then probably yes. Can you cut off all federal funding on all law enforcement over refusal to investigate one specific federal gun law? Maybe not. Maybe that gets close to the Obamacare line. How about this from the challenge to sanctuary cities in the last administration? Can the executive add new conditions to previous legislative grants? Well, that probably depends on the underlying statute. Did Congress leave the executive discretion? Well, we all know that spending allocations that Congress makes leave a lot of leeway to the executive branch. That was the core of the debate over defunding sanctuary cities. It didn't appear in court. To the best of my knowledge, certainly no final decisions. It's done now. So to the future extent that a gun control happy federal executive tries to co-opt local law enforcement by holding purse strings, we'll see that play out again. The second limit, however, is much more political. There just aren't that many federal law enforcement officers. And along with state and local agencies, they have priorities set from their head of agency. Federal priorities aren't the same as state. So usually everybody works more or less together and more or less muddles through with varying levels of cooperation that allow each agency to focus on its own priorities for the most part. A local agency might decide that enforcing certain federal laws is not a priority, but that doesn't really leave the feds able to simply walk away and have nothing more to do with the locals. While the feds can try to cut off funding for specific local priorities to try to maintain cooperation, it runs into political limits if you appear too punitive. None of this is case law, obviously. The real key, I would suggest, is that the squeaky wheel gets the grease. If your state or local government makes the loudest noise about non-enforcement and non-cooperation, it will get the most attention from a dissenting federal executive. Finally, there's significant pressure on locals as well, going the other direction. We all oppose seeing repeat offending violent felons have guns. And while that's a state crime, it's also one where federal assistance in investigation and even prosecution of major cases is beneficial. No state or local law enforcement wants to lose the assistance of the feds in getting violent armed felons off the street. So political pressure for federal-local cooperation runs both ways. So local control of state government, close to my heart, as I said, out here on the West Coast, statewide politics, well known, they're dominated by concentrated coastal urbanites, while vast swaths of the state have strongly divergent views on the Second Amendment. New state gun laws rarely have broad support, if any support at all, in the more sparsely populated counties. And those local jurisdictions have responded. A number of Oregon counties, for example, have passed local county laws banning county employees. The sheriff and his deputies, the county prosecutor's office, banned from enforcing state gun laws, imposing fines on those officials if they do. That's being challenged in court. Is that a legal act by a county government under the Oregon Constitution and Oregon state law? In Washington, several sheriffs made very clear public statements that they would not enforce a statewide gun control initiative that they viewed as unconstitutional. Of course, these get pushback. The court challenges in Oregon. Another place to expect pushback is recall elections, which the same states out on the West all have recall provisions. Here in Washington, the sheriff, an elected official, can be recalled for malfeasance in office. So the question arises, is refusing to enforce a state law that he views as unconstitutional such malfeasance? Well, the state Supreme Court gave a couple answers as to sheriffs who publicly denounced COVID mask mandates. In one instance, the sheriff was subject to recall, among other reasons, and there were several, but among other reasons, when he said that he wouldn't enforce it because he had reviewed the mask mandate and determined that it was unconstitutional, the state Supreme Court said he was engaged in the unauthorized practice of law, subjecting him to recall. Another sheriff made similar but less vigorous statements and talked about enforcement priorities and having his deputies talk to people and so on and so forth. He was not subject to recall. Sounds to me like the squeaky wheel gets the grease. I'll give one final example of an issue raising tensions between state priorities and local law enforcement that I worked on for Second Amendment Foundation. We resolved it without litigation. It really wasn't the proper subject of litigation because it is about discretionary authority. So the 2020 riot season, as we all know, drove many first-time gun buyers to decide to exercise their Second Amendment rights. This had the salutary effect of informing a lot of undereducated voters about the scope of existing gun regulation. No, you can't just walk into a gun store wearing a mask with a wad of hundreds and walk out with a shiny new pistol. And of course, some who filled out the background check form learned that they were disqualified from gun ownership due to issues in their past. Several aggressively anti-gun prosecutors decided that they would charge these first-time prospective gun buyers who were denied for process crimes, false swearing on the application. Many elected officials, state legislature, some avid proponents of the Second Amendment, but others as well, saw cause for concern. We wanted buyers to go through legal channels. We want background checks run. We want to exclude felons and the mentally ill from gun ownership and possession. If a person's obviously trying to evade the system with multiple applications in different locations, that's one thing that might merit prosecution. But we thought that if it became known a would-be first-time buyer could be prosecuted for a felony after learning through the proper execution of a background check that he was not permitted to purchase, especially if that person didn't purchase, declined to try to procure a gun through illegal means, left matters alone, that probably doesn't merit prosecution. In fact, if word got out that that's what was going on, people might avoid the background check system entirely and move straight to the black market. So we thought these zealous anti-gun prosecutors were arguably making the state less safe, dissuading people from legal purchase through the background check system. Of course, they thought they were dissuading purchase, but when we pointed out that they could just as well be encouraging a black market, the prosecutions dried up. Politics played the primary role. In sum, the ability of various levels of government, federal, state, and local, to operate as checks on one another has a very little bit of case law, a little bit of constitutional background, a lot of money involved. And finally, the political reality of divided government and pressure that can be brought to bear on elected officials is probably the most overwhelming. With only a couple relevant US Supreme Court cases, it's clear that our ability to urge state and local officials to work in favor of Second Amendment rights rather than against them comes primarily from the power of the voices of their constituents and not from federal and state judges. Thank you very much for giving me the opportunity to speak on these important issues.
Hello, my fellow patriots. My name is George Lee, and I'm an attorney with the firm of Seiler Epstein LLP in San Francisco. I was lead counsel for plaintiffs in the case of Miller versus Bonta, a challenge to California's assault weapons ban, which we filed in federal district court in San Diego. It was my privilege to represent plaintiffs such as Second Amendment Foundation, Firearms Policy Coalition, San Diego County gun owners, and other organizations and individual plaintiffs. And my thanks go out to all of you who have supported these organizations throughout the years that made cases like Miller possible. Miller was a historic and important win for firearms rights. It was the first time that gun rights prevailed at the district court or the trial court level in a challenge to a state's assault weapons ban. It was also important because we were finally able, using evidence, to dispel many of the myths that surround so-called assault weapons, as that term may be used by various state laws. So if you're a fan of Adam Kraut like I am, you might appreciate it when I say we were able to crush some of the many myths that surround so-called assault weapons. And today I'd like to tell you about 3 of the myths that we were able to successfully dispel using evidence in court in the Miller case. So the first myth that the state continued to propagate in defending and justifying its law was that somehow the existence of these generic assault weapons characteristic features such as flash suppressor, pistol grip, collapsible stock, that somehow these features made a semi-automatic firearm more inherently dangerous than other semi-automatic firearms. As the state was claiming in its pretrial submissions to the court, in which it was arguing that assault weapons are inherently dangerous, it claimed that each of these features serves, quote, specific combat-oriented functions which increase the lethality of firearms and enhance their effectiveness in certain types of crimes, particularly mass shootings and violence against law enforcement personnel. But we showed at trial that this is simply not true. One of the things that we admitted into evidence at trial was a video taken by our friend Adam Kraut, in which he fired the same rifle in two different configurations. First was California legal configuration, and it was legal under California law because it lacked those features such as the flash suppressor, pistol grip, or collapsible stock. Second, he took that same rifle and simply reattached those features into the standard AR-15 configuration that you're familiar with. What he was able to demonstrate using this video is that he was able to hit a man-sized target at 25 yards effectively and rapidly with no material difference. He was even able to perform a magazine change between the two different configurations, with no material difference in the time that it took for him to do so. The trial judge thought that this video was particularly interesting and helpful in demonstrating that the existence of these features, although they may be important to a law-abiding average citizen to whom accuracy and ergonomics and training may be vitally important, to someone who is intent on committing indiscriminate killing or some type of other crime, the existence of these features made no material difference. Another myth that we shattered at trial was that California's assault weapons ban banned modern technology which is only useful on the modern battlefield. In essence, what the state was trying to claim was that the assault weapons ban essentially banned firearms such as the M16, which only has usefulness on the battlefield, according to the state. But through the testimony of the capable firearms historian Ashley Lubinsky, who we used as an expert witness at the trial, we were able to demonstrate that many of the features that California's law prohibits long predate modern sporting or military firearms. For example, pistol grips, which seem to be the main point of contention for the state, appear on firearms that go back to the 1700s. Flash suppressors are found on firearms that go back to both World War I and World War II. And as for the AR-15, I think as we all know, this is essentially technology from the 1950s. Through the use of expert historical testimony, we were able to successfully refute this whole idea that California's assault weapons ban bans those modern firearms which only have application on a battlefield. Another myth that we destroyed is that somehow assault weapons constitute these high-powered weapons which fire uniquely devastating ammunition. Now you hear this all the time in news reports and in media where the police say they recovered a high-powered rifle at the scene of a crime or a mass shooting. Here, the state repeated its myth when it tried to claim that assault weapons fired some type of exotic rounds which will, quote, typically defeat normal bullet-resistant body armor used by law enforcement. Another state's expert witness, an emergency room physician, tried to testify that assault weapons cause uniquely devastating injuries, claiming that, quote, individuals who have been shot by assault weapons tend to have more wounds and injuries that are far more extensive, These weapons cause significantly more damage and have resulted in higher morbidity and mortality than other weapons. But what we showed at trial was something that we all know. The most popular types of rifles, such as the AR-15 or the AK-47 variant, fire what is known as an intermediate cartridge, which is far less powerful than your traditional hunting or military rounds. In a book by Dr. Vincent DeMaio, who was recognized as the leading authority on gunshot wounds and its effect in the body, said, "One of the common fallacies about assault rifles is that the wounds produced by them are more severe than those due to regular military rifles and hunting rifles. In fact, the wounds are less severe, even when compared to such venerable hunting rifles, such as the Winchester M94 and its cartridge, the 30-30. And in cross-examination, that physician for the state, he had to concede that he wouldn't be able to tell the difference between a wound caused by an AR-15 or a Ruger Mini 14, which fires the exact same bullet, the .223. As to this myth that assault weapons somehow were uniquely capable of penetrating police body armor, even the state had to concede that almost all rifle rounds will penetrate most police body armor. You know, you hear these myths repeated over and over by anti-gun advocates or the media who are simply repeating what they're told. But when push comes to shove, and these myths are actually tested in court with evidence, they simply don't hold up. Which is why it's important to continue to support organizations such as Second Amendment Foundation, Firearms Policy Coalition, or your local organization, such as San Diego County Gun Owners, so that we can continue to bring cases like Miller and test these myths in court. Thank you so much for your support.
Hello, everyone. The GRPC 2021 event. My name is Donald Kilmer. I'm an attorney that has worked for the Second Amendment Foundation for, I think, going on more than a decade. I have various cases in my office in which staff has an interest or is funding the case or is actually a plaintiff in the case. The lead case that we're working on right now, which may or may not be resolved by the time, at least at the district court level, by the time this video is shown during the conference, is a case called Doe versus United States. The case is about the restoration of rights after a mental health hold. There are two kinds of mental health holds in most jurisdictions. There are unadjudicated mental health holds, which have no federal consequences, but may in fact have state consequences, as they do in California. And then there are adjudicated mental health holds, which result in a lifetime prohibition of the right to keep and bear arms under federal law. But as we'll see, the federal government does provide a way to restore the rights if a state has complied with or joined a grant program that the federal government has put out there for guidelines on what are proper procedures for restoring rights. And in fact, most states, more than 35 states, have already signed on to this. California has not joined in this grant program, which made for some complicated issues in this case. There was a case out of the Sixth Circuit which dealt with this issue, Tyler versus Hillsdale. It was a case that went up to the Sixth Circuit en banc, where the court there found that unless there was a procedure for restoring the right to keep and bear arms under the state where Mr. Tyler resided, that the federal scheme would be unconstitutional under the Second Amendment. The case did not proceed any further, nor did it go back to the trial court for resolution of Mr. Tyler's issues, because Mr. Tyler fell ill and the case did not proceed further than that, and there were no additional plaintiffs. The case we put together here in California is to either achieve the same result as Tyler versus Hillsdale or create a split within the circuits that hopefully the U.S. Supreme Court may take a look at this issue. We have 6 plaintiffs, 7 if you count the Second Amendment Foundation. They have various circumstances under which they had lost their right to keep and bear arms, and may or may not have had their right to keep and bear arms restored under either state law or under a theory that the federal government is stopped, which would mean they're prevented from asserting mental health hold because the federal government had allowed this person into the military and allowed them to use firearms as part of their military service. The case is somewhat complicated because California is a point of contact state, which means California is one of the few states in the country that actually does all of the federal work on the background check in the state of California, in addition to its own state background check. So California is sort of deputized to do the federal work here in California. Case is further complicated because the court will have to resolve whether or not, even if a state does not participate in the grant program, that there is a way for the people who live in that state to have their rights restored, and that's one of the issues that's before the trial court in this case. One of the things we're asking our trial judge to do is to find that California's procedure either meets or exceeds the federal requirements, even if California did not participate in the grant program, and then whether or not a California judge going forward can simply apply the federal standards under the federal statute to a state court proceeding, and then whether that federal government would be required to accept that as a valid restoration of rights hearing. If not, then we're asking the court to find that the entire scheme is unconstitutional under an equal protection clause, or under an equal protection theory of the case. That being because more than 35 states have implemented this federal program. They have accepted grant money from the federal government, and people in those states are getting their rights restored. And our position is that the people of California, just because their state will not participate in a grant program or a federal standards procedure, should not have their right to keep and bear arms impacted for the rest of their lives. Because as we know, under federal law, you can't live in California and then go buy a gun in, say, Utah or Idaho, and then come back to California. So that it just doesn't work that way. A new issue arose in the case that we're keeping an eye on, and we did fully brief to the court, but the defendants are screaming bloody murder about it, is that we actually discovered that California's adjudication procedure, the initial hearing to place somebody on a mental health hold, may be defective under a case called Addington versus Texas. Now, this was a case that was mentioned by Justice Alito in a concurring opinion by the U.S. Supreme Court in the case that arose out of the First Circuit this term, that had to do with caretaker exceptions to the right to keep and bear arms and seizure of firearms in cases like that. So we're keeping an eye on that as well. We're hoping the judge will allow us to sort of amend the theory of our case. If not, we have other plaintiffs, and we will bring a second suit and build upon the work that we've done in this suit, and we hope to proceed on that. The issue there is that the California statute for adjudicated mental health holds is that the evidentiary standard is preponderance, or actually it's lower than a preponderance evidence. It's based on probable cause. And Addington versus Texas stands for the proposition that for a mental health hearing to deprive somebody of a liberty interest, and of course your Second Amendment is a liberty interest, that the proof or the evidentiary burden must be by at least clear and convincing evidence. So we think that's a pretty big deal. We hope the judge will let us use that issue in this case, even though it was a late-breaking issue. And then if not, then we'll build upon the work we've done in this case and bring another lawsuit with new plaintiffs. Couple of other cases that my office is handling. An active case is Herndon versus the city of Sandpoint. This case is docketed with the Idaho Supreme Court right now. We obtained an adverse decision in a trial court in Sandpoint. The case has to do with whether the city can, under a sham, what we believe is a sham lease of a public park, allow a private entity, in this case a music festival, to ban firearms in a public park at a music festival. We don't believe that they can do that under either Idaho land use law or under Idaho's strong preemption statutes and the right to keep and bear arms in Idaho. Our trial judge disagreed with us on what we consider to be some pretty flimsy legal theories. So we're going to go ahead and ask the Idaho Supreme Court to review that. A case that is in a pre-filed status at this point, tort claims have been submitted, is going to be a repeat of a case that we won for the Second Amendment Foundation in 2020, actually the tail end of 2019 going into 2020. And that was the gun show case out of the Del Mar or San Diego County Fairgrounds. The agricultural district that runs the fairgrounds there had placed a moratorium on gun shows for a year. It was a case I worked on with Chuck Michelle and some of his very fine lawyers at his firm, Anna Barvier and Tiffany Chevreau. We brought a case, sought a preliminary injunction, and prevailed, at which point in time the 22nd Agricultural District wanted to settle the case. We did. We obtained damages for the gun show promoter and a restoration of attorney's fees for staff and, of course, for the gun show promoters. The state of California, apparently in a bid to challenge whether the First Amendment applies to them as well as it does to the 22nd Agricultural District, has decided to pass a statute banning gun shows at the Del Mar Fairgrounds. It's based on a state statute instead of a agricultural district regulation. We won the case in 2019 based on First Amendment grounds, not Second Amendment grounds, because it was a violation of a freedom of assembly or freedom of association. So look for that case to be filed sometime later this year, and I'll keep you posted on that as well. I've been hired also by the Second Amendment Foundation to assist with a case in Montana where the regents that run the universities in Montana, the state universities of Montana, believe that they can override Montana state law and forbid firearms on campuses when there is no Montana law allowing them to do that. So that's simply going to be an assist from staff from my office to assist the gun owners and gun rights supporters in the state of Montana with their briefing on that Montana issue. Doe or Roe versus United States is the big case in my office right now. We expect a decision from the district court sometime before the end of August or early September. It's expected that the case will probably be appealed up to the Ninth Circuit by either party, depending upon who prevails. Thank you very much for your support, and thank you very much for supporting the Second Amendment Foundation. I couldn't do the work I do without your help. Thank you.
Hello, I'm David Thompson of Cooper & Kirk, and I'll be addressing the Supreme Court's upcoming decision in NYSRPA versus Bruin. Let's start with the legal landscape. There are over 40 states in which law-abiding American citizens have an absolute right to carry a firearm outside of the home for protection. But there are a small handful of liberal blue states that deny ordinary law-abiding American citizens the right to carry a firearm outside of the home. These include New York, New Jersey, California, Massachusetts, Maryland, and Hawaii. How do they do that? Well, they have a requirement that you need to show a good reason in order to be able to carry a firearm. What qualifies as a good reason? If you live in a crime-infested area and you want to have a firearm to protect yourself and your family, that's not a good reason in the laws of these states. If you're just an ordinary law-abiding citizen and you want to carry a firearm for any reason, for protection, hunting, it doesn't matter. You cannot do that in these jurisdictions. New York City is such a place, and so the plaintiffs in this lawsuit challenged that regime. The Supreme Court has agreed to hear the case. It's being briefed, and it will be argued in November of 2021 with an argument and decision to follow in June of 2022. So what are the key arguments? Well, we start with the text of the Second Amendment. The right of the people to keep and bear arms shall not be infringed is crystal clear. Then, as now, the word bear means to carry. You can see that in Samuel Johnson's definitive dictionary. You can see that in Noah Webster's dictionary. That should really be the end of the matter. But it's likely the Supreme Court will also look to history, and the history is equally clear. We can start with the practices of the founders. George Washington frequently carried firearms for his personal self-defense. So did John Adams. John Adams also acknowledged during the Boston Massacre trial that there was a right of ordinary law-abiding citizens to carry a firearm. Thomas Jefferson told his nephew, "Let your gun be your constant companion. James Madison carried frequently, as did James Monroe and John Quincy Adams. The choice for the United States Supreme Court could not be clearer. Either the Supreme Court brands the first 6 presidents of the United States of America as habitual criminals, or it acknowledges that the historical tradition was such that there was a right to carry a firearm for the purpose of self-defense. And it wasn't just the practices of the founding generation, it was also the laws. There is no law at the time of the founding that prohibited ordinary citizens from carrying. There are other laws that in fact mandated carriage in many states at the time of the founding. There were also laws that prohibited slaves from carrying a firearm. Why would you need a statute prohibiting slaves from carrying a firearm if nobody had a right to carry a firearm? The one thing the other side points to, the state of New York, is the Statute of Northampton. This is an English law from 1328. You heard me right, from 1328. Now you might say, what is the significance of a law that is 700 years old from another country? Well, there were certain jurisdictions at the time of the founding that had a law that was somewhat analogous to the Statute of Northampton, but they were very clear, clearly understood, only to apply when carrying was done to terrify people. The case law is very clear about that, and the practices of the founding are also very clear about that. We can see that there is a right to carry a firearm for law-abiding citizens from the purposes identified in Heller as well. It's not just the text and the history, but the purposes of the Second Amendment, which include the right to self-defense, which obviously requires the ability to carry a firearm outside the home. We can see it from the right to fight tyrannical governments. Obviously, the battles of Lexington and Concord were not fought in people's living rooms. And we can see it from the right to hunt, which again, obviously takes place outside of the home. The bottom line is that the text of the Second Amendment is clear, the history is clear, the purposes are clear, and the plaintiffs should prevail in these cases. And if they do, tens of millions of Americans will have their constitutional rights honored and restored. Thank you.
Hello, I'm David Sigale. I'm speaking to you from Wheaton, Illinois, just outside Chicago. I've represented the Second Amendment Foundation, or staff, for a number of years, and I'm also counsel for the Illinois State Rifle Association, which I'll call ISRA. And there's a number of issues here in Illinois going on. Maybe if I have time, some other issues outside of Illinois, and let's get moving on it. Illinois is one of 2 states where you are required to have a license to possess a firearm. Illinois, to also purchase one, you need to have this license. It's called a FOID card, Firearm Owner's ID card. By state law, when you apply for one, the state has to act on that application within 30 days. They don't do it. The state also requires that if you want a concealed carry license, you have to have a FOID card. When you apply for your CCL, you can submit or not submit fingerprints. If you don't, the state has 120 days to act on your application. If you do, they have 90. The state police, the ISP, doesn't do that either. When your FOID card is revoked or denied, you have to file an appeal. There's no deadline in the law for when an appeal has to be ruled upon, and as it turns out, some people are waiting years to hear back on their appeal. So between the failure to act on FOID applications and CCL applications and FOID appeals within either the allotted statutory time or just any reasonable measure of time, all 3 of those issues are the subject of federal lawsuits, which are all pending in the same federal Northern District of Illinois court before the same judge. The FOID application case is called Marszalek. FOID appeal is called Thomas. I think now it's Singleton. And the and the CCL application case is the Luce case, Luce. Those are all pending. They are in various pleading stages or discovery stages. We are fighting to get those cases moved forward. In the meantime, the ISRA is working hard on a grassroots level to try and get these horrendous policies and procedures changed and fixed. And so taking a two-pronged attack, and we are going to continue fighting until the state's horrible backlog, which has been brought on. COVID certainly didn't help, but it's a personnel and money and apathy problem that predates COVID. COVID just made it worse. So we are going to continue to fight until this horrific situation that denies people their Second Amendment rights is fixed. The next issue is called the Miller case. Miller is in Central District of Illinois. It seeks to protect the Second Amendment rights of foster parents and home daycare operators who are prohibited from having functional firearms in their homes to protect themselves and their family. It's two different cases, two different issues, but it is they've been combined into one. We are nearing the summary judgment stage, and we are continuing to fight for those issues as well. The next case is a case that the Meyer case, Meyer. It is in the Southern District of Illinois. It is with SAF and ISRA and the attorneys at the Firearm Policy Council in California. So forgive me if you already heard about this one. But 18 to 20-year-olds are prohibited from obtaining concealed carry licenses, even if they have FOID cards. We believe that's unconstitutional. And with all those organizations and some very solid individuals, some really good people, we're looking to change what is an unfair law and an unfair situation. The next case is the Vivian Brown case. This is a woman that was arrested in her home for having a rifle, a bolt-action rifle, and she didn't have a FOID card. She was eligible for one, but she didn't have one. She got arrested. The criminal trial court threw the case out and declared the whole FOID law was unconstitutional. That matter went up to the Illinois Supreme Court last September, and they manufactured basically a technical reason to kick it back to the trial court. Well, now it's back at the Illinois Supreme Court. It has the briefing is barely underway, and we believe the Illinois Supreme Court is going to have to address this issue of whether people who are law-abiding and wish to have a long gun, that's the specific issue, in their homes for self-defense are required to jump through the hoops of obtaining a state license to do it. The trial court, as we said no, that's not constitutional, and now it's back at the Illinois Supreme Court. So more on that one in the future. The next case is the Easter Day case. That is the Deerfield, Illinois, a suburb of Chicago, banned assault weapons. We believe that this was in violation of state law, which 5 years before, when the Illinois concealed carry law was passed, gave municipalities a 10-day window to ban these firearms if they wanted to do so. Deerfield did not. They put on some other restrictions, but they didn't ban them. And now we're arguing that when they sought to ban them 5 years later, that they were violating Illinois state law. The trial court agreed with us. The appellate court agreed with Deerfield. And now the case is not back, but the case is up at the Illinois Supreme Court right now. It has been briefed. We're waiting on an argument date. And we believe, again, that Deerfield violated the law, and hopefully the court will agree. The next case is the Oster case. Madison Oster was a high school student, and you might recall, after the terrible events at the tragedy in Parkland, Florida, a number of schools held student walkouts. They were not the schools themselves, but the students walked out of class in protest. Ms. Oster wished to hold up pro-Second Amendment, pro-police signs during her school's protest and was prohibited from doing so by the school. With SAF and ISRA's support, Ms. Oster sued the school, and I'm happy to report a couple years later that the matter's been resolved to Ms. Oster's satisfaction, and we're very proud of her for standing up for her rights. She's also now an officer in the United States Army, and she's thriving there, and very proud of her for her service as well. The next issue is out of state. I mentioned the Miller foster care case. There were foster care cases elsewhere. One was in Missouri called the Attaway case. The state changed its law, and we were able to resolve that case. They gave us what we wanted, and so there was no more fight. In Michigan, the case, same issue. The state is changing its law. It's currently in the legislative process. They're also going to be implementing training procedures to make sure that the caseworker employees respect Second Amendment rights, don't discriminate against anyone in licensing, and because they wish to exercise Second Amendment rights. And while there will be more on that later, we're glad and we're optimistic that thanks to the state changing the law, that might be resolved as well. The next issue is in Tennessee. SAF has sponsored, basically, as supporting a gentleman in public housing outside of Nashville. He had a firearm in his home, which was against the lease. And when he had to defend himself because he got attacked by someone with a firearm, they threw him out. They argued that it violated the lease, and so we are on appeal now. SAF, again, is sponsoring his appeal in Tennessee State Court. A federal case is also imminent because someone who is of limited financial means and needs to avail themselves of public housing shouldn't sacrifice their constitutional rights as a result. Well, it looks like I'm about out of time. If you're here in Illinois and you have a FOID situation, know that there's many people that unfortunately are forced to have to go to court to get their FOID rights restored, either through the Illinois State Police or in court. And feel free to contact me if you need to discuss those kind of issues. But we are working on making the situation better for everyone. Thank you for listening, and enjoy the rest of the conference. Thanks to SAF and also to ISRA for all they do. And to everyone, take care. Bye-bye.
Good afternoon. My name is David Jensen. I'm an attorney in New York, and a significant amount of my practice concerns the Second Amendment. In particular, I've handled a number of cases that concern right to carry and that challenge the constitutionality of restrictive discretionary license issuance policies. So I am here today to discuss the issue of discretionary handgun carry licensing laws, the current state of affairs within the United States, as well as the issues that are before or potentially before the Supreme Court in the NYSRPA v. Bruin case. So to begin with, as things stand right now, we have 9 states that have licensing standards that are in some manner discretionary. And those break down into 3 basic groups. We have, first of all, centralized licensing schemes where the operation of the licensing standard is a matter of firmly established state law, and there's very little room for an individual licensing official to make an exception or apply some other policy. Roughly 5% of the U.S. population lives in a jurisdiction that has a centralized restrictive licensing scheme, and those states are Hawaii, Maryland, and New Jersey. In the second category, we have what I call localized licensing regimes, and those are licensing systems where, while they have a discretionary component, a requirement of cause or reason, for example, the actual interpretation of that discretionary component and its application is delegated to local officials. And there are 3 states that have those policies: California, Massachusetts, and New York. In total, about 20% of the U.S. population is living subject to restrictive or potentially restrictive localized licensing regime. Then last, we have 3 states, Connecticut, Delaware, and Rhode Island, that really don't fit particularly well into the prior 2 categories, but at the same time, these states still have schemes in place that make issuance of a license turn, at least in some circumstances, on a discretionary determination, meaning that how the licensing scheme operates may not be entirely clear, and it may vary from time to time. So we'll start with the centralized licensing regimes. First, we have Hawaii. Hawaii makes 2 different types of licenses available: a license to carry concealed and a license for unconcealed carry. Based on the language in the statute, the takeaway would appear to be that a private citizen is only able to apply for a concealed carry license, which is available in an exceptional case when an applicant shows reason to fear injury to the applicant's person or property. The statutory language that goes along with an unconcealed carry license is, among other things, requires that someone be engaged in the protection of life and property. When this law was being challenged in litigation, in the Young versus Hawaii case, the Hawaii Attorney General issued an opinion stating that an open carry license was not limited to individuals with an occupation that involved the protection of life or property, such as security guards or bodyguards, but that the open carry license would also be available for any individual who could show, and this is quoting the Attorney General's letter, a need for protection that significantly exceeds that held by an ordinary law-abiding citizen. Now, the next state is Maryland, and by statute, Maryland requires good and substantial reason and gives an example of good and substantial reason as being such as a finding that the permit is necessary as a reasonable precaution against apprehended danger. Now, the state issues licenses from a centralized agency, and appeals from license denials go to a centralized state board. So the result of that is that practices are reasonably uniform, although it has been noted in the past that in Maryland in particular, the precise composition of the Handgun Permit Review Board will vary, at least to some extent, based on who's in the governor's office. So at times it becomes somewhat easier or somewhat more difficult to obtain a license in Maryland. Normally, people who have success getting licenses in Maryland, at least this has been my observation, are able to point to an occupational or employment-related reason that justifies their request for a license. Now, finally, we have New Jersey. By statute, New Jersey requires justifiable need, and since roughly the late 1960s, that need requirement has amounted to what they term an urgent necessity for self-protection as evidenced by specific threats or previous attacks which demonstrate a special danger to the applicant's life that cannot be avoided by means other than by issuance of a permit to carry a handgun. Now, previously, that standard was adopted by judges designated to hear permit applications throughout the state. It was subsequently upheld and laid down as a statement of law by the Supreme Court of New Jersey in a 1971 decision called Sigale versus State. And subsequent to that, New Jersey State Police took that restrictive standard and codified it in state police regulations. In 2019, after Governor Chris Christie had made some effort to slightly liberalize the need standard in New Jersey, the New Jersey legislature amended the underlying statute to codify that restrictive standard that had first been put in writing, or at least publicly put in writing, by the New Jersey Supreme Court in 1971. Now, one aspect of these centralized may-issue systems is that they typically have very low issuance rates. At the time of Young versus Hawaii, when it was before the Ninth Circuit, the state of Hawaii reported that it had not issued any, at least open carry licenses to private citizens, and reports prepared by the Hawaii Attorney General generally indicate that in most years, no licenses whatsoever are issued. I will just note that I have heard some anecdotal evidence that would suggest there are at least a few of these being issued, but whatever the actual answer is, it seems pretty clear that the issuance rate in Hawaii is very, very low, if not zero. Now, Maryland, on the other hand, has not quite 28,000 permits in force, which as a percentage of state residents amounts to just under 0.5%, which is definitely the highest rate among the centralized may issue regimes. One thing that should be noted, and this is also true with New Jersey, is that that number of permits that's being provided includes not just residents, but also non-residents. So whatever the percentage of the state population is that is licensed to carry a handgun, it is actually going to be at least somewhat lower than that 0.46% figure. In New Jersey, we have what is, within the context of the continental United States, definitely the most restrictive regime. Based on disclosures we've obtained in litigation, we know that there were a total of 1,112 permits issued in the years 2018 and 2019. Each license lasts for 2 years. So it stands to reason that at the end of 2019, there were roughly 1,112 permits in force. And as a percentage of state residents, that is 0.013%. And to give this some contrast, at least according to John Lott's publication, Concealed Carry Permit Holders Across the United States, the overall rate of licensure among the adult population is 7.6% throughout the United States. Now, turning to the localized may issue systems, the essential characteristic of all of these systems is that there's some sort of somewhat vaguely stated standard, cause or reason, that is tied to the issuance of a carry license, but state law does not itself answer the question of what that cause or reason requirement really amounts to. So in California, there are 2 different licenses available. There's a license to carry concealed, and there is also a license that is available in some of the less populated counties that allows for open carry. Aside from requiring localities to publish a written policy and make it available, state law doesn't dictate what that policy is. In Massachusetts, the statutory requirement is good reason to fear injury or for any other reason. And again, aside from stating that this is a requirement to obtain a license, Massachusetts statutes don't provide any guidance on what is actually needed to meet that standard, nor do regulations or judicial decisions. In New York, the statutory standard is proper cause, and we will discuss this at some additional length in a couple minutes here, since that is the issue that is before the Supreme Court in NYSRPA v. Bruin. But for now, suffice it to say that the statute does not define proper cause, and court decisions addressing the issue are at best opaque. One consequence of localized may issue systems is that there is a wide degree of variation in terms of actual issuance policies. I've included maps that attempt to show local level policies in California, Massachusetts, and New York. I believe the California map is more or less accurate. Both the Massachusetts and New York maps are at least somewhat outdated. And in particular, in the case of New York, this is in no small measure because the only way to actually get information about what is going on within any particular county is to ask people who live there what they know about what is going on. There's no centralized data storage that would indicate the number of unrestricted carry licenses that are being issued. Now, another characteristic of localized may issue systems is that at a local level, they are easier to change. So what we have seen is that generally changes in the past few years have been in a positive direction. In California, notably Orange County, San Diego County, and Sacramento County all changed from having very restrictive policies on the issuance of concealed carry licenses to having relatively permissive policies that allow people to obtain licenses without making an onerous showing. And there have been counties, there are counties other than Orange, San Diego, and Sacramento. Those just happen to be three counties that have relatively large populations. In Massachusetts, the most licenses are issued by localities, by towns and cities where people live, meaning that there are roughly 355 different licensing jurisdictions throughout Massachusetts. And working with Commonwealth Second Amendment in particular, we've been able to get changes made at several of these localities in recent years, including Lowell, New Bedford, Weymouth, and Worcester. Significantly, the issue in both Massachusetts and New York is whether or not a handgun license is issued with restrictions. And a license that is issued without restriction generally authorizes the carry of an operable handgun in public, and the significance being that in both Massachusetts and New York, the handgun license that's being issued is generally needed to purchase and possess handguns in the first place. So in Massachusetts, even though licensing decisions are being made at the local level, the actual physical license cards are being issued by the state, and they're included in a central database, so we're able to see how many licenses have been issued with restrictions and without restrictions. And what we can see is that throughout all of Massachusetts, just over 91% of licenses were unrestricted in 2015, and 6 years later in 2021, nearly 96% were unrestricted. So it has really become a situation where there's only a handful of licensing jurisdictions that are problematic, that are routinely issuing licenses subject to restrictions. In New York, most licensing decisions are being made by county judges who are elected, but it is often also the case that individuals involved in local politics, including the county legislature as well as the sheriff's department, may make significant input on what local policies should be. So in Putnam County, which is very close to where I live, for a period of about 10 or 15 years, local authorities were normally issuing restricted handgun licenses. There was an organized campaign to elect a judge that would be more protective of people's Second Amendment rights, Judge Reitz. And the result of that is that now, in the normal course, people in Putnam County are able to obtain unrestricted licenses, although they may have to wait some period of time, a few months, and take a class to do so. In Erie County, on the other end of the state, they had historically, Erie County has normally issued restricted licenses, in no small measure due to efforts by Lieutenant Governor Kathy Hochul back before she was Lieutenant Governor. They adopted a system several years ago under which people who have held restricted licenses for 5 years can apply for unrestricted licenses. Obviously, 5 years is a rather long period of time to be denied your constitutional rights on the one hand, but on the other hand, this does reflect a significant improvement from the prior practice in Erie County, and it should perhaps be noted that it appears that Kathy Hochul will likely be our governor in the near future. When we look at the localized may issue systems, what we generally see is that they result in a higher rate of licensure than do the centralized may issue systems. California is currently reporting a little over 120,000 permits. There are no, or as a practical matter, no non-resident permits in California. So that amounts to 0.31% of the general population. In Massachusetts, the number is significantly higher. There are just over 416,000 unrestricted licenses, and that matches up with just over 6% of the population. Although it should be noted that licenses are issued to both residents and non-residents in Massachusetts, so the percentage of the population that is licensed is in fact almost certainly at least somewhat lower than that 6.04% figure. Now, when we get to New York, the truth is we really don't have a very good grasp on what is going on. Traditionally, while copies of approved license applications and amendments were sent to Albany and kept on file, they weren't put into a centralized data file, meaning that we don't have a good handle on exactly how many licenses are in force at the present time, nor do we have a handle on how many of those New York licenses are restricted versus unrestricted. John Lott prepares a publication every year in which he discusses the number of licenses that are in force in the United States, and he came up with the number 196,132 by surveying some counties and then extrapolating across the state. Candidly, I think that number is too low. There was a FOIL request back in approximately the year 2010, and that revealed over 1.2 million licenses between two computer systems Now, the problem is some of those licenses appear to be duplicates, and when I say duplicates, I mean there appear to be duplicate entries both within each system, and there are likely also duplicate entries across the two systems. On top of that, it appears that those license entries include licenses that have been canceled because people have passed away. So if that number that we got from the FOIL request was accurate, that would be a little over 6% of the population. We still wouldn't know how many are restricted versus unrestricted. The actual number is likely somewhat less than that. So about all we can really say is it looks like it's between roughly 1% and roughly 6%. Now, there are three other states that don't really fall squarely in line with the 6 states we just discussed. They are, first of all, Connecticut. And the big kicker with Connecticut is that the licensing standard itself is a may issue standard that doesn't really say too much of substance besides may issue. Local authorities and or the state may issue permits to carry pistols or revolvers. The kicker with Connecticut is that anyone who is denied a license to carry has the right to appeal to the Board of Firearms Examiners, and by statute, they will review the matter de novo, meaning they will make their own new determination, and they are directed by statute to issue a license unless they find there is just and proper cause for denial. So effectively, this works out to a situation where, while local authorities and state authorities have the ability, at least theoretically, to deny licenses on the ground that someone doesn't have sufficient need or cause or proper purpose, what have you, in actual application, people have essentially an entitlement to obtain a license if they file an appeal. Now, at the end of the day, Connecticut winds up being a state that has a number of licenses in force, over 271,000, which matches up with about 7.6% of the population. However, that 271,000 number includes a significant number of non-resident licenses because Connecticut, like every other state we've been talking about up until now, does not recognize out-of-state licenses. However, Connecticut does issue licenses to non-residents on relatively reasonable terms. So there are a number of people, in particular people in New York and Connecticut and New York and Massachusetts and Rhode Island, who have obtained Connecticut licenses. Now, Delaware is a little bit different because, most notably, in Delaware, a license is only needed to carry a concealed handgun. Someone who is otherwise in lawful possession of a handgun would not be prohibited from carrying that handgun in open view, although, to state what might be apparent, that is not to say that carrying a handgun around in a populated part of Delaware might not result in some unwanted attention. If someone is applying for a concealed carry permit, then the licensing official is the superior court, and the licensing standard is stated to be a may issue standard, and then the statute actually explicitly provides that the judge may or may not, or the court may or may not, in its discretion, approve any application. Now, one other wrinkle that comes up in Delaware is that Delaware actually has a reciprocity law that at the present time recognizes 21 out-of-state licenses. What we understand to be the case in Delaware is that in the normal course, someone who submits an application to the court for a license will be issued the license as long as they meet the other statutory requirements, training, age, background, etc. And put simply, there's no good reason to deny them. However, I'm not aware of any official source that says that. Overall, just over 2% of the population of Delaware is licensed, and that figure should be reasonably accurate because for the most part, Delaware does not issue non-resident licenses. Now, the last state we have is Rhode Island, and Rhode Island is a little bit of a difficult nut to crack because it actually has two different licensing systems. There's one run by the Attorney General that is stated to be a may-issue system that requires a proper showing of need, and there is another licensing system that local officials run that uses shall issue language, but also has a requirement for good reason to fear an injury or any other proper reason. Now, the Supreme Court of Rhode Island has generally indicated that the local level licensing option is, to use their term, mandatory, and that notwithstanding the reference to good reason to fear an injury or any other proper reason, a person who meets the statutory requirements has an entitlement to obtain a license. Notwithstanding that, there's been some back and forth on this. In recent years, there have been a decent number of towns in Rhode Island that have either refused to process applications for licenses or have instead simply applied the standard that is applied by the Attorney General's office. There was a federal court case in 2016 that concerned the town of Bristol, where the denial at issue basically went exactly opposite to what the Rhode Island Supreme Court had previously said in Mosby versus Devine. Subsequent to Mosby versus Devine, the Rhode Island Supreme Court has issued another decision in 2015 reiterating that a proper showing of need is not required for the local level license. Now, exactly how many licenses are in force in Rhode Island is a bit of an open question. The number reported by the Attorney General as of the end of 2019 was 2,069 permits, which would line up with 0.19% of the population, which is obviously a very small number. It appears to me that the number being reported by the Attorney General is only the number of licenses that the Attorney General has issued. And if in fact that is the case, then the actual licensure rate would be significantly higher because it is reasonably well known among gun owners in Rhode Island at this point in time that applications submitted to local authorities are supposed to be decided on a shall issue basis, while applications submitted to the Attorney General are decided on a may issue basis and require a showing of need. In terms of what the actual difference is between those two licenses, one from the Rhode Island Attorney General and one from a town in Rhode Island, the Attorney General license authorizes carry in either an open or concealed manner, while the local license authorizes carry only in a concealed manner. Now, since the law at issue before the Supreme Court in NYSRPA v. Bruin is the New York statute, we're going to take a closer look at the history of that statute and what it allows as a matter of right and allows as a matter of discretion. So the original Sullivan law was enacted in 1911, and it prohibited the possession of handguns without a license any place, but it did not provide any licensing standard. It just said a written license, and it left it open for local cities, villages, and towns to adopt their own policies. One thing that should be noted, by the way, in looking at this original 1911 law is that while it says that it applies only in any city, village, or town within New York, all of the state of New York is divided up into cities, villages, and or towns. So that it may as well say who shall have in his possession anywhere in the state. Now, in 1913, the legislature amended the Sullivan Law to put in place the basic framework that is still here today, which is that a licensing officer is directed to issue a license to have and possess a pistol or revolver to either a householder to have in a dwelling, or alternatively to a merchant or a storekeeper to have in a place of business. Conversely, to obtain a license to carry away from one's home or business, one needs to show proper cause, and if that is shown, then the licensing official is authorized to issue a license to have and carry concealed. Since 1913, there has not been any license available to private citizens without some sort of occupational justification that would allow carry in open view. Now, as the New York law exists today, there are 7 listed purposes that justify the issuance of a license. We continue to have a license being available as a matter of right to have and possess in a dwelling and to have and possess in a place of business. Then there are licenses to have and carry concealed that are available to various people, messengers, judges, certain employees of the state, corrections officers, etc. And beyond that, an individual seeking a license to carry a handgun would need to apply for a license to have and carry concealed, which, as in 1913, as now, requires proper cause. In terms of what proper cause actually entails, the courts of the state of New York have given very little affirmative guidance. There was a 1943 appellate court decision that the Court of Appeals affirmed without opinion that upheld the denial of a license to have and carry concealed sought for the purpose of target shooting, unorganized target shooting, it should be noted. And the essential rationale was simply that it had been a proper exercise of discretion by the delegated local official. Now, significantly, the next year, the New York Attorney General issued a decision or an opinion stating that target shooting or recreational shooting could in fact be proper cause for a handgun license. And then over 30 years later, the third department, the same appellate department that had upheld the denial of the target license back, or the license sought for target shooting back in 1943, said that target shooting was a legitimate purpose and actually overturned a licensing official's decision to deny a license sought for use in organized target shooting, but did so in part by noting the ability to issue a restricted license. And on that front, the issuance of licenses to carry handguns subject to restrictions is a practice about which we only have so much information, both because, as previously stated, there's no centralized repository of records that indicates how many licenses are restricted or unrestricted, as well as because it appears that the actual genesis of this practice took place, if not behind closed doors, then at least not in published sources. So there was a 1964 report by the New York State Commission of Investigation that noted that among the 10 licensing jurisdictions it had surveyed, one had begun issuing restricted licenses in 1961. By the time, and that is, to my knowledge, the very first reference that exists anywhere in writing that reflects the issuance of handgun licenses with restrictions on them. By 1991, at least according to information provided by the Attorney General's office during an oral argument, about half of handgun licenses throughout the state of New York were restricted. And in 1994, the Court of Appeals upheld the practice of issuing restricted handgun licenses. And as is typical, the court did not provide a positive statement of what proper cause was. It simply said that the power to determine the existence of proper cause inherently includes the power to restrict the use to the purposes that justified the issuance. One final thing that should be noted is that carrying a handgun outside of one's restrictions is not a criminal offense, although having said that, it most certainly can result in disciplinary action such as revocation of one's license. So in conclusion, I would like to appreciate you for attending my presentation, and hopefully we will have some significant additional guidance from the Supreme Court when it issues its decision in NYSRPA v. Bruin. Thank you.
My name is Dan Schmutter. I'm an attorney in New Jersey and New York. I'd like to tell you about one of the cases that I'm working on right now called Kendrick versus Graywall. It's a case that's pending in the United States District Court for the District of New Jersey. And one thing I really like about this case is I like to call it a big tent lawsuit. That's because it includes a whole series of organizations all working together, a whole bunch of Second Amendment groups. It's not just Second Amendment Foundation, it's also Firearms Policy Coalition, Association of New Jersey Rifle and Pistol Clubs, which is the NRA State Association for New Jersey, Coalition of New Jersey Firearm Owners, New Jersey Second Amendment Society. So it's nice to see a really broad coalition of groups like that, and I'm very glad to be part of it. So this is a challenge to New Jersey's firearms permitting system. I'm not talking about carry permits. Everybody knows that New Jersey has an extremely onerous carry permit law. I'm talking about the basic system for permitting to acquire and possess firearms. Just the basic right to possess firearms. And to be clear, this is a system that puts real obstacles in the way of the exercise of the right to keep and bear arms. We're talking about multiple forms, fingerprints, background checks, references, delays, appeals in court, that kind of thing. This process has lots of hoops to jump through in order to exercise one's constitutional rights. This is a mess. Now, the way the system works, New Jersey has two basic types of permits just to acquire and possess firearms. There's the Firearms Purchaser Identification Card, usually called the FID card, and what's known as the Permit to Purchase a Handgun. Now, the FID card is required for a number of things, but mainly it's to acquire and possess long arms, rifles and shotguns. As you probably guessed, the permit to purchase a handgun is a permit that you require to acquire a handgun. Now, the thing is, every time you want to acquire a new handgun, you have to go through the process all over again. So you need a permit every single time you buy a handgun. So you have to do the entire process, start to finish, for each purchase. Now, the process for the permits, for both permits, is essentially the same. There are several substantial forms to fill out. You have to answer numerous questions. You have to obtain fingerprints from the state-approved digital fingerprint provider at substantial cost. You have to provide 2 references. The police do a very substantial background check. This process can and does take months, very often. Now, we've documented through the Association of New Jersey Rifle and Pistol Clubs permitting strike force project enormous delays throughout the entire state, sometimes lasting more than a year. So this presents real hoops to jump through just to exercise a fundamental constitutional right. So what the lawsuit does is it asserts that it is a violation of the Second Amendment to require a pre-approval process like this that stands in the way of the exercise of a fundamental constitutional right. I mean, it's that straightforward. Now, what's notable about this is that New Jersey sees that as a feature, not a bug. New Jersey is proud of the fact that New Jersey law makes it difficult to exercise the constitutional right to keep and bear arms. This is something that New Jersey wears proudly on its sleeve. Now, we've seen that the deprivation of this fundamental right can literally be fatal, as we saw in the very tragic Carol Bown case. Carol Bown was knifed to death in her driveway by her violent ex-boyfriend while she was waiting for the police to approve her permit application. So the gist of the case is pretty straightforward. Now, those of you who are familiar with the Supreme Court's Heller decision may recall that the court approached the Second Amendment by looking into the text, history, and tradition surrounding the right to keep and bear arms. And what this did was it allowed the court to understand what's known as the original public meaning of the Second Amendment. That is, how people would have understood the right to keep and bear arms in the Second Amendment at the time it was written and ratified. Now, why is that important as an approach to understanding the Constitution? Well, the reason is that the Constitution is understood to have been written for the people, for people to read and understand. So if you want to know what the provisions of the Constitution mean, what you should do is you should look to what the original meaning would have been understood to be by the public at the time of ratification. So you want to look to how would these words, how would this language have been understood at the time by ordinary people? What would they have understood these words and provisions to have meant? That's the concept of original public meaning. And this is important because of the original public meaning of the Constitution that should govern how courts apply its provisions even today. Now, one of the reasons this is important to understand is that there's a theory of constitutional interpretation called living constitutionalism. The idea that the Constitution is a living document that changes on its own over time. This is effectively the assertion that the Constitution can be altered merely through the court system. That the courts have the power to update our fundamental law whenever they want to, based essentially on their own judgment as to what the people's rights should look like. Well, obviously the better view is that, and it's the view that commands a majority of the Supreme Court today, is the idea that the Constitution must be understood based on the original public meaning of its provisions, subject to alteration in the manner provided by the Constitution itself, the amendment process. So, importantly, at the time the Second Amendment was ratified, and also as well as the time the 14th Amendment was ratified, and the reason the 14th Amendment becomes important is because originally the Bill of Rights was intended as a constraint on the federal government. But as a result of the ratification of the 14th Amendment, one of the things the 14th Amendment did was to make the Bill of Rights enforceable as to state law and local law. And so when we want to understand the original public meaning of these documents, we want to understand the original public meaning not just at the time of the ratification of the Second Amendment, but also at the time of the ratification of the 14th Amendment, because that's what they were doing in incorporating these provisions as against state and local law. And so, both at the time of the Second Amendment and at the time of the 14th Amendment, there was no tradition of imposing these kinds of onerous obstacles like a permitting system, a complex system like New Jersey's permit process, to stand in the way of a fundamental constitutional right. There was no such thing. They would not have seen any such thing, and they would not have believed that type of thing could be required to stand in the way of the exercise of fundamental rights. When the Constitution was written, the idea that folks could be forced to jump through onerous hoops merely to exercise their fundamental rights would have been completely foreign to them. That's a fundamentally modern concept, this idea that somehow it's okay to infringe on a fundamental right in that way. Well, it's not okay. And it's utterly inconsistent with our Constitution. And it's the goal of this lawsuit to have the courts confirm that states like New Jersey just can't disparage our fundamental rights merely because they disagree with the exercise of those rights. And we've gone to court to confirm and enforce that understanding. Thank you.
Hello, GRPC. My name is Alan Beck, and I'm here to speak to you about a case that I am litigating called Young v. State of Hawaii. Young is a challenge to Hawaii's handgun carry laws. We started the case back in 2012, and my client, George Young, filed the case pro se after applying for either a handgun carry permit to carry openly or concealed. After he was denied for both, he filed suit challenging both provisions of the law, and he alleges in his lawsuit that he would like to carry one way or another and does not have a particular preference as to the manner that he carries. He simply wants to carry in some fashion, be able to defend himself when he leaves his home. In Hawaii, originally, you have to show an exceptional case for concealed carry, and as a practical matter, open carry meant to carry just for security guards, and that was the express and remains the express written policy of the county of Hawaii where my client lives. The county of Hawaii is the Big Island. And as I'll cover in a few minutes, that's changed in the course of this litigation. So he files pro se, and this was his third lawsuit, and was dismissed without a hearing. He wasn't even allowed to show up to court. So that's after the motion to dismiss. We had actually been in contact due to a previous lawsuit that I had filed, and I decided that I was going to represent him. This is when I filed a notice of appeal to the Ninth Circuit Court of Appeals. And we sat there for several years. And in 2018, after the Pruda case was decided, that was the case where the Ninth Circuit said that there is no right to carry concealed outside the home. We were allowed to have oral argument. And during oral argument, the county of Hawaii conceded that they have never issued a concealed a carry permit of any kind to a private citizen. And a three-judge Ninth Circuit panel, including Judge O'Scanlan, Judge Akuda, and Judge Clifton, ruled in our favor. Afterwards, the state of Hawaii, along with the county, filed a motion for rehearing or en banc. And after that, they proceeded to effectively rewrite their law, where they now claimed that you can be issued an open carry permit in Hawaii despite quite a bit of overwhelming evidence. And it just simply is the matter of the case that either no one had ever applied for one, or that there simply weren't records of those applications. Well, that is now the at least arguably the state of the law in Hawaii. So you need an exceptional case for concealed carry, or a sufficient urgency or need for open carry. But again, the county has never issued one, and statewide in the past 20 years, only 4 concealed carry permits have been issued. So that gets us to the en banc proceedings. After the case was heard, we had a briefing in front of the en banc panel, and we had arguments a little over a year ago. In front of that, we had the composition was of the court was not as favorable for the Second Amendment right, and the Ninth Circuit ruled against us. As I mentioned, concealed carry has already been ruled as not being protected by the Second Amendment in the Peruta case. So in Young, the Ninth Circuit said that there is no right to open carry either. So that means there's no right in their eyes to simply carry a firearm outside of your home. That created a sort of interesting situation because this is the first court to ever say that you have no right to carry a firearm outside the home for lawful self-defense. There have been other jurisdictions, the Second Circuit, Third Circuit, and the Fourth Circuit, that have said that, have assumed that there's a right, but rationing your rights to a select few is okay under something called intermediate scrutiny. Now, presumably, if you're listening to this, you agree with me and believe that's a bunch of malarkey. But still, they at least were willing to undergo a legal fiction that there is a Second Amendment right that extends outside the home. Now, there was a very clear, what Young did, the Ninth Circuit did with Young, is create a very clear circuit split with the Seventh Circuit and the D.C. Circuit, which has already struck down carry regimes. They were somewhat similar in nature. And along comes the New York carry case, which is currently before the Supreme Court, and it at least was relevant to the consideration of the justices that this very large circuit split had been created. Now, Young is currently on a petition for certiorari in front of the United States Supreme Court. And it's different than the New York case because it deals with both open and concealed carry. Right now, I've filed a petition. The opposition has been filed by the state of Hawaii and the other defendants, and I'm currently working on drafting a reply to the opposition. That'll get us to September 17th. After I file the reply, we will have the next conference for Supreme Court petitions. That's when they decide whether they're going to grant a case or not. And right now they're in the summer recess, which is why there aren't any conferences right now. And I believe that there's a good chance the Supreme Court will take this case because it offers a little bit more easier question for the justices to answer, which is whether there's simply a right to carry whatsoever, because as many of you know, there is a lot of laws that restricted concealed carry, throughout American history. That was always when you could open carry. So there's a good chance, so those are much distinguishable. This is I believe to be a cleaner vehicle, and that's how the Young case is relevant to gun rights right now. And, just stick around for September 17th, and we'll all know whether the Supreme Court's either going to take it, hold it, pending the outcome of the New York case, or at least readily to me, deny it. So that is the Young v. State of Hawaii case. Thank you for listening.
I'm Chad Flores. I'm a partner at Beck Redden LLP, a litigation boutique headquartered in Houston, Texas, and I specialize in appellate litigation and impact litigation in the constitutional and administrative law fields. For the past several years, I've had the pleasure of representing the Second Amendment Foundation and other leading litigants in a series of cases about emerging issues in the Second Amendment field. And today I've been tasked with updating you all on how some of that litigation has been going, to show you some stories from the front lines and exactly where things are at the cutting edge. The case we're going to talk about today is Defense Distributed and the Second Amendment Foundation versus the New Jersey Attorney General. The case is being litigated in a couple of places. One is in federal court in Texas. There's another in federal court in New Jersey. And the one that we'll be talking about today is currently at the United States Court of Appeals for the Fifth Circuit. The question presented here is about the First Amendment combined with the Second. Defense Distributed and some of the Second Amendment Foundation's members lead an emerging field of 3D printing technologies, whereby users can take raw information about firearms and firearm components and combine that with an amount of technical acumen and raw materials and 3D printing machines to produce firearms and firearm components of a surprisingly impressive quality that is vastly improving by the day. The question presented in this case is whether the state of New Jersey can criminalize the exchange of this speech, the exchange of information about 3D printing technologies. So the case is now before the Fifth Circuit with a two-front war. Front number one is the constitutional merits of the case. The First Amendment rights at issue, whether this speech is entitled to First Amendment protection, which it seems to be clearly yes, and whether states can actually enact crimes that criminalize the exchange of this speech. And the answer there seems to be clearly no. So Defense Distributed and the Second Amendment Foundation have a commanding lead on this front, the first front about the constitutional merits. But front number two in this litigation is a procedural war. The Second Amendment opponents, like the state of New Jersey, know that they are weak in substance, and as a result have resorted to all manner of gamesmanship in an attempt to avoid a ruling on the merits, or at least stave off a ruling on the merits, or have those rulings occur in forums that they like better than places like Texas and the Fifth Circuit. And so what we're going to present here are some exchanges from a recent oral argument where the Fifth Circuit judges are grilling the officials of the New Jersey Solicitor General's office. What you'll see is what seems at times like two ships passing in the night. One side of the litigation wanting to talk about the merits and seemingly scoring huge points about questions like First Amendment coverage and questions like the overbreadth of these statutes. And on the other side, the opponents not engaging in that debate, but instead trying to shift the field to procedural questions that eschew the actual substance of the debate, and you can see how that plays out.
We do intend on enforcing Section 3L2 against anyone who may violate the law.
Well, let me read to you what 3L2 says. Stripped to its essentials, facilitating the manufacture of a firearm using a three-dimensional printer. It is a crime for any person to distribute by any means, including the internet, as used in this provision. Distribute means to sell, manufacture, give, provide, lend, trade, mail, deliver, publish, circulate, disseminate, present, exhibit, display, share, advertise, offer, or make available by any other means, blah, blah, blah. And that is a crime punishable by 3 to 5 years imprisonment. Well, distributing on the internet, let's say they had a silencer that they wanted to distribute on the internet. That would violate this law, would it not?
Not if they restrict it to outside of New Jersey, which is
Has anyone been indicted under that law yet, even in New Jersey?
With respect to 3L2, I believe the answer is no, Your Honor. There are other aspects of the law.
Am I right that the Third Circuit can certify to get interpretive views, but we never have authority?
Absolutely. The New Jersey Supreme Court only allows certification from the Third Circuit.
Are you familiar with the Supreme Court's recent remand to our court in McKesson, asking us to certify a question for state court? Are you familiar with that case?
I am not, Your Honor.
Is there any aspect of this law that is constitutional?
I believe all of it is constitutional, Your Honor.
Of course you do, but publishing is is anything put on the internet speech?
I think many things on the internet are speech, Your Honor, but just because it's on the internet doesn't mean it is speech.
Well, related to that question, it is true, Judge Jones did dissent, 5 years ago, saying someone's got to answer the First Amendment question. And although I don't agree
That exclamation and quick attempt to redirect the force of the argument is one of the examples we'd like to show you. And here's a second example of a similar interaction.
Let me ask you a question. You know, the premise of your so you don't have a beef with them if they're restricting the publication of files so as to prevent internet distribution to New Jersey ISPs. Well, I might be able to understand that if New Jersey had suddenly gone on a campaign against pornography, and it said, we don't want any more child pornography coming in to any New Jersey ISPs. But the premise of the argument has to be that what is on the internet is not speech. Or if speech is speech of a character that is not protected. And that's where your problem comes in, as far as I'm concerned, because they are still prevented, chilled, by the possibility of being sent to jail because of this regulation, right?
Your Honor, as to your question about the First Amendment and what is and isn't speech, I think the issue is that Defense Distributed hasn't given this court the ability to rule on that issue because they never filed for a preliminary injunction in the district court, as we understood that they would, and as they told the Western District of Texas that they would. They filed their Second Amendment complaint, but no preliminary injunction followed. And so therefore, without that satisfaction of Rule 8, this court has no record on which to determine whether the district court did or did not commit error in fact-finding. And fact-finding is necessary to reach the conclusion on the First Amendment because we, as the New Jersey Attorney General, would have to put in evidence about what compelling state interest there may be on any level of scrutiny with speech.
But you can't regulate speech, any kind of speech, just because you say you have a compelling interest.
Well, certainly some speech can be regulated.
Yeah, well, that's the whole point here, isn't it? And New Jersey has yet to have to argue about that. And you say, oh, yeah, take the case to New Jersey. And then you'll, then they'll be litigating in two forums again, won't they? But anyway, I repeat myself.
Your Honor, just on that last...
No, I appreciate your argument. You've had at least 5 minutes extra, and I don't mean to disrespect your position or that of your state, except to say you've had more than enough time.
Thank you, Your Honor.
All right, thank you.
The upshot we have is that for Second Amendment advocates who are most right on the merits, you can expect your opponents not to join issue there in substance, but to use procedural gamesmanship, and that the way to attack that is with patience and persistence. We are cautiously optimistic about this case and look forward to the court's ruling. The YouTube website of the Fifth Circuit has the full argument, and we commend it to everyone.
My name is John Ohlendorf, and today I want to talk about the dominant test or doctrinal framework that federal courts have used over the last 10-plus years or so to decide Second Amendment challenges to restrictions on gun use or ownership. In the Second Amendment context, like in several other areas of constitutional law, including the First Amendment, the Equal Protection and Due Process Clauses, courts generally analyze the constitutionality of a challenged law or restriction by using the so-called tiers of scrutiny approach. Now, constitutional lawyers will generally tell you that there are 3 tiers of scrutiny. First, laws that restrict some constitutional rights are analyzed under strict scrutiny, which requires the government to show that the challenged law is necessary to achieve a compelling government interest. Second, restrictions on other rights are given lesser intermediate scrutiny, which requires the government to show that the challenged law or restriction substantially furthers an important government interest. And then finally, laws that don't fall into one of the first 2 buckets get the weakest rational basis review, the weakest tier, which only requires that the law be rationally related to a legitimate government interest. Now, since District of Columbia versus Heller, the case in which the U.S. Supreme Court held that the Second Amendment protects an individual right to armed self-defense, most lower courts have adopted and applied a particularly deferential form of what they call intermediate scrutiny in the Second Amendment context. And in my remarks today, I want to argue that this is wrong, and that not only should courts not be applying intermediate scrutiny in Second Amendment cases, they really shouldn't be applying one of the tiers of scrutiny at all. And I want to begin with the history of the whole tiers of scrutiny framework, because I think it helpfully shows that this doctrinal approach is not solidly rooted in the Constitution's text or original meaning, and in fact is inconsistent with it. At the founding of the nation, and for most of American history, really up until the mid-20th century, courts did not apply any of the tiers of scrutiny, strict, intermediate, or rational basis review. Instead, courts basically just tried to figure out what the scope or boundaries were of the government's power and of the Constitution's restrictions on the use of that power. And then if they determined that the law or government action that had been challenged transgressed the boundaries drawn by the Constitution, then that challenged law or action was unlawful. And it wasn't really until the mid-20th century, again, that the tiers of scrutiny approach began to take shape, and it was at that point that the Supreme Court began using the strict scrutiny doctrine in First Amendment cases. And even then, it wasn't as though the justices on the court had uncovered some new historical research or evidence indicating that strict scrutiny was the most faithful way of interpreting the Constitution. Instead, the strict scrutiny doctrine, and then later intermediate scrutiny and the rest of the framework, were adopted essentially as a political expedient to bridge the various factions on the court at that time, and they were adopted as a way to uphold laws challenged under the First Amendment, even though those laws appeared to fall within the scope of what the First Amendment protected and didn't allow the government to infringe. So essentially, strict scrutiny, although it's now considered the strongest of the tiers of scrutiny, was really adopted initially as a way of balancing away our First Amendment freedoms. And I think this history indicates that the tiers of scrutiny were really not adopted because they were thought to be consistent or faithful to the Constitution's text or original meaning. And in fact, I think the history shows that at least for most constitutional provisions, the tiers of scrutiny approach is contrary to the text and original meaning of the Constitution. And I also want to suggest that even setting that point aside, the tiers of scrutiny framework is also just analytically unsound even on its own terms. And that's because the tiers of scrutiny are really hopelessly indeterminate and therefore incapable of meaningfully guiding or constraining judicial decisions in most cases. Begin with the first step in the scrutiny analysis, which is to determine whether the government has advanced a sufficiently important or compelling interest in support of the challenged measure, again, depending on which tier of scrutiny is being used. A basic difficulty with this step is that judges simply don't have any scale on which to weigh the government interests that are being asserted and sift the compelling from the important or from the merely legitimate. There's no objective measure of these things, and the Constitution itself certainly doesn't provide such a measure. So in practice, what happens is that courts basically end up deferring to the government's assertion that its interests in, for example, public safety or national security or public health are indeed important and compelling. And when we move to the second step in the scrutiny analysis, the situation does not improve or become more determinant. That step, recall, is for the judge to determine whether the challenged law sufficiently fits the purported government interest and is properly tailored to advance that interest, or under the strict scrutiny tier is necessary to advance that interest. But again, determining these questions of fit and tailoring in really any contested constitutional challenge is going to depend on judgment calls and on competing subjective evaluations of very complex and controversial empirical questions, questions of social science, such as whether, for example, restrictions on certain types of firearms actually advance public safety, or whether there are alternative measures that are less restrictive to Second Amendment rights, but that also further the government's interests in an equally effective way. And again, the point is not that judges are especially well equipped to decide these types of contested empirical or scientific questions. The point is that given the completely understandable judicial reluctance to second guess the political branch's assertions on these matters, right? The governor or legislature or Congress or the president's assertions that these measures are necessary to further public safety or national security, judges are simply going to end up, in most cases, again, deferring to those assertions. And the result is that we are really fooling ourselves if we think that this second tailoring prong adequately protects our fundamental constitutional rights, including our fundamental Second Amendment rights. Now, the very predictable result over the last decade in Second Amendment litigation, for example, is that courts have effectively balanced away our fundamental constitutional rights. In case after case, the federal courts have rejected Second Amendment challenges to all kinds of draconian gun control measures, basically bans on carrying firearms outside the home, bans on even possessing certain types of firearms. And basically they've upheld all of these laws, first by concluding that the government's interest in public safety is compelling, and then second by essentially just completely deferring to the government's say-so that the challenge restriction will help to promote public safety. Now, in a Second Amendment case that the Supreme Court is hearing in the 2021 term, however, the case New York State Rifle and Pistol Association versus Bruin, the Supreme Court has a very important chance to correct this misguided framework and the lower court's misguided use of the framework to rubber stamp restrictions on firearm use and possession. The court should take the opportunity of this case to reject the use of intermediate scrutiny or any of the tiers of scrutiny in the Second Amendment context, and instead it should take the opportunity to instruct the lower courts that they should analyze restrictions challenged under the right to keep and bear arms under a test that faithfully hews to the Second Amendment's text, history, and tradition, a test unlike the scrutiny framework. And more generally, the court should use this case as an opportunity, even outside the Second Amendment context, to begin cutting back on the use of the tiers of scrutiny approach more generally. For the reasons we've talked about, that tiers of scrutiny framework is inconsistent with the Constitution's text and original meaning. It's analytically flawed and incapable of constraining or guiding judicial decision-making. And the court should use this opportunity to begin the process of rolling back the domain of the tiers of scrutiny framework and returning constitutional law to a form of analysis that is more faithful to the document's text and history.
Good afternoon. My name is Josh Blackman. I am a constitutional law professor at the South Texas College of Law, Houston. I'm also very proud to be affiliated with the Second Amendment Foundation. For several years now, I've been working on the 3D printed gun litigation with Defense Distributed, and I'm happy to work with staff as we fight to protect our First and Second Amendment rights. My topic today is corpus linguistics and the Second Amendment. And this talk is a preview of a new paper I'm writing with Professor James Phillips at Chapman University Law School. Constitutional litigation is often binary. There are two outcomes, right? The Supreme Court will pick one of two competing readings of the Constitution. For example, in Heller, the Supreme Court held that the Second Amendment protects an individual right to keep and bear arms. But the dissent disagreed. The dissent said the right was collective in nature. Was Heller correctly decided, or did the dissent have the better argument? Heller was a case of first impression. There was no precedent that the court could rely on. Rather, the court was interpreting the Constitution from a blank slate. The majority and the dissent considered a wide range of factors: text, history, structure, practice. No single factor was dispositive. It is tough to grade the accuracy of such complex decisions in their entirety. But we can focus on part of it here in my brief time. Heller relied on textualist arguments. That is, what is the meaning of the text of the Second Amendment? Now we have a new way to assess how accurate the majority and dissent were. We have a tool called Corpus Linguistics. Corpus Linguistics. Linguistics meaning language. And corpus means body. Right? Think of like the body of Christ, Corpus Christi, right? We have these databases, these bodies of language, these systems that index how language is used. Corpus linguistics is a method for studying how language is used. And corpus linguistics allows us to assess the accuracy of Heller and the Second Amendment landmark decision. The Second Amendment provides a well-regulated militia being necessary to the security of a free state. The right of the people to keep and bear arms shall not be infringed. As we all know, Justice Scalia wrote the majority opinion in Heller, and he concluded that the Second Amendment protects an individual right to possess a firearm unconnected with service in a militia, and to use that arm for traditionally lawful purposes such as self-defense within the home. In short, an individual right. Justice Stevens dissented. He contended that the Second Amendment is most naturally read to secure to the people a right to use and possess arms in conjunction with service in a well-regulated militia. That is a collective right. Justice Scalia and Justice Stevens each made linguistic claims about four elements of the Second Amendment. Number one, right of the people. Number two, keep and bear arms. Number three, keep arms. Number four, bear arms. Both the majority and the dissent used various textualist approaches to consider these four phrases. But their toolkit in 2008 was limited. They considered only a fairly narrow range of sources to interpret the text. Justice Scalia admitted that his analysis was limited to the written documents of the founding period that we have found. Likewise, Justice Stevens' dissent cited dozens of contemporary texts, dozens. Over a decade later, big data allows us to perform much more sophisticated queries. Our work relied on the Corpus of Founding Era American English. The Corpus of Founding Era American English. It's abbreviated to COFEA. COFEA, C-O-F-E-A, it rhymes with Sophia. COFEA contains over 100,000 texts of approximately 140 million words. That's a lot of words. And it covers a very important time period from 1760 to 1799. Why those years? King George III's reign began in 1760 and George Washington died in 1799. COFEA allows us to parse the 27 words of the Second Amendment in dynamic ways with information that was simply inaccessible in 2008 when the court decided Heller. We will discuss several tools and practices used in corpus linguistics research, frequency data, concordance lines, coding collocations, and clusters, also called n-grams. And this research will help us figure out what is the better reading of the Second Amendment. We also review some of the works of other scholars who have made corpus linguistic claims about the Second Amendment. You may have heard of some of these people. Professor Dennis Barron, Professor Alison O'Croy, Josh Jones, and our favorite scholar, Neil Goldfarb. Each of these scholars put out their analyses, and there are some problems with them. And our paper, which is not quite ready yet, will discuss some of their analyses. Our work itself performed 3 primary queries. We queried right of the people. We queried keep and bear arms and synonyms of those words. We queried the word right within 6 words of arms. We queried the word keep and variants of keep within 6 words of arms. We queried the word bear and variants of bear within 6 words of arms. And we tried to take care to reduce coding risk, coding bias. We use a double-blind methodology, and different coders who independently coded the results. So this was done to minimize the risk that we would affect how the work was being coded. In the end of our paper, we actually grade the 4 linguistic claims made in Heller. Not quite ready to reveal our research yet, but I'll have to admit, both the majority and the dissent made errors. They both did. Justices Scalia and Stevens should have expressed more caution when reaching their textualist conclusions based on the narrow subset of founding era sources they reviewed. On balance, a corpus linguistics analysis shows that the meaning of the operative clause of the Second Amendment is much closer than the Heller majority of dissent were willing to admit. There's linguistic evidence that supports both sides. But I think we should keep in mind that Heller relied on far more than just linguistic evidence. And we don't look at the other methodologies that inform the original public meaning of the Second Amendment. We also don't look at the Second Amendment as applied to the states by virtue of the 14th Amendment. Both James and I agree that on balance, Scalia had it better than Stevens, but I think we shall be candid that neither opinion was perfect. One final note, our work has been cited extensively to criticize Scalia. We also found that Stevens made quite a number of mistakes, and in many regards his work was a bit sloppy. He had some good points, but he made some errors, and I think any careful analysis of corpus linguistics should look at both the majority and the dissent. Now, I'm sure some of you are asking us, how does this affect the pending New York rifle and pistol case? And it's a good question. From our perspective, corpus linguistics is more helpful in some cases and less helpful in others. The Second Amendment's a complex provision. It has a prefatory clause and an operative clause. It has very complex grammar. It has several verbs, several nouns, and several objects. This may not be the ideal provision to use corpus linguistics for. By contrast, if we want to know what the word commerce meant in the Commerce Clause of the Constitution, that may be a more simpler corpus linguistics inquiry. Let me stop here. I'm just over my time. I'd like to say thank you to everyone at the Second Amendment Foundation and to all my friends. Hopefully we'll see you all in person soon enough, perhaps with the Supreme Court victory to celebrate. Thank you.
Hello, I'm Matthew Goldstein. I'm one of the attorneys working on SAF's lawsuit against the Bureau of Alcohol, Tobacco, and Firearms, which is currently pending before the United States District Court for the Northern District of Texas. In this case, SAF and several SAF members challenged ATF's failure to follow congressionally mandated rulemaking requirements in its attempt to impose National Firearms Act restrictions on stabilizing arm braces. Well, after SAF filed its lawsuit, ATF finally published a proposed rule allowing public comments until September 8th of this year. And so I'm here today to talk about ATF's proposed rule, how it impacts Second Amendment rights, and how to submit a public comment. Stabilizing arm braces were created to provide shooting support to disabled combat veterans. ATF initially acknowledged that pistols equipped with stabilizing braces are not subject to the National Firearms Act in 2012. Since that time, millions of stabilizing braces and stabilizing brace-equipped pistols have been sold, and the Congressional Research Service reports that there is an estimated 10 to 40 million stabilizing braces in private hands inside the United States. ATF published its first proposal to impose NFA control on stabilizing braces over the 2020 holiday season and left only 17 days for public comment. This action violated congressionally mandated rulemaking requirements, and so SAF challenged that rule on procedural grounds in the Northern District of Texas, Dallas. The parties were scheduled to exchange cross motions for summary judgment, but then the Biden administration issued its gun control actions in April of this year, which gave the Justice Department 60 days to issue regulations on stabilizing braces. And so the Justice Department requested, and we agreed to, a stay to suspend proceedings in the district court because of ATF's impending publication of the proposed rule, which is the very rule I'm here talking about today. As reflected in the proposed rule, which was published by ATF on June 10th of this year, ATF seeks to reclassify millions of stabilizing brace-equipped pistols as subject to the NFA, which would trigger NFA paperwork requirements, taxes, long wait times, and transfer restrictions for the affected firearms. ATF's proposed expansion of NFA control will not only impact how new guns are equipped with stabilizing braces, but would also affect millions of existing pistols lawfully in private hands that are equipped with stabilizing braces. The NFA was not amended for these changes. Instead, ATF decided to change the scope of the NFA on its own. Central to its plan to expand NFA control, ATF's proposed rule sets forth a point scoring scheme for use in applying the NFA restrictions. The scoring scheme is non-exhaustive, vague, highly subjective, and it overcomplicates what is already an overcomplicated matter. Under the point scoring scheme, a pistol must not be too long or too short. It must not be too light or too heavy. A configuration can be penalized for having sights and for not having sights. And while ATF provided 3 examples in the proposed rule to illustrate its proposed brace and firearm scoring methodology, the examples instead illustrate how seemingly identical firearms can be subject to vastly different government controls. SAF's public comment explains the many problems with ATF's proposed rule and how it threatens to infringe on the Second Amendment rights of SAF members and other firearms owners. In addition to all the substantive problems with the proposed rule, and adding insult to injury, ATF also changed its proposed policy for payment of the NFA tax. Less than a year ago, in its initial proposal, ATF proposed to waive the NFA tax and expedite application processing for gun owners affected by the rule change on the stabilizing braces. Now, unlike its earlier 2020 notice, ATF's proposed rule does not include any provisions for an NFA tax waiver or for expedited processing. Also note, in the proposed rule, ATF states it will not consider any public comments that were submitted in response to its initial proposal in 2020. And so any commenters to that proposed rulemaking would need to submit new comments to the most recent proposed rule if they want to be heard. Now until September 8th is the time for SAF members and others, including those who have submitted their comments to the prior rule, to now submit public comments to this proposed rule. You can submit your public comment to ATF via the federal e-rulemaking portal, at the address that's shown on the slide there at www.regulations.gov. And again, those comments should be submitted on or before September 8th of this year. Each comment must reference docket number ATF 2021R-08. That number is posted up there on the slide as well. Again, ATF number 2021R-08. And comments should be original. ATF is not going to consider any duplicate comments, and the comments should also be professional in tone. ATF does not consider any comments with profanity or other inappropriate content. If you'd like to, instead of sending it electronically, submit your comment by paper, you can mail written comments at the address shown on the proposed rule, which is reproduced on the slide up there. Mail comments, and of course, any comments in writing should be in 12-point font size or larger. It should include the commenter's first and last name, full mailing address, be signed, and again, be submitted by the deadline on or before September 8th of 2021. Please feel free to share this information with others so that ATF can hear their voices as well. And thank you for watching.
Hello, my name is Pete Patterson. I'm a partner at the law firm of Cooper & Kirk, and I'm here today to talk about the Second Amendment rights of 18 to 21-year-old adults, an important issue that is being litigated in federal courts across the country. I'll first sketch out briefly the argument against the notion that 18 to 21-year-olds have diminished or non-existent Second Amendment rights. I will then discuss some of the cases that are being litigated in this area. As we all know, the Second Amendment provides a well-regulated militia, being necessary to the security of a free state. The right of the people to keep and bear arms shall not be infringed. As Heller made clear, the people in the Constitution generally means all Americans, not some unspecified subset. And there is no other context in which constitutional rights do not fully vest by age 18. Any doubt on this with respect to the Second Amendment is removed by founding-era understandings of the militia. To fulfill the purpose announced by the prefatory clause, the Second Amendment, at a minimum, must protect the members of the militia. And there is zero doubt that at the founding, 18-year-olds were considered members of the militia. Indeed, in the Militia Act of 1792, enacted the year after ratification of the Bill of Rights, Congress generally mandated that upon turning 18, each male citizen was required to enroll in the militia and provide himself with a firearm. Opponents of the Second Amendment rights for 18 to 21-year-olds make three principal arguments, all of which lack merit. First, they say that at the founding, 18 to 21-year-olds were considered minors. And while that may have been true for some purposes, the history we have just discussed refutes any notion that 18 to 21-year-olds were considered to have anything less than full Second Amendment rights. Second, they point to late 18th century restrictions certain states had on the rights of 18 to 21-year-olds to acquire firearms. But these laws, which were enacted in a minority of states, cannot supplant the founding-era understanding, and Heller makes clear that it is the founding-era understanding that controls. Third, they cite statistics purporting to show that 18 to 21-year-olds are disproportionately likely to engage in criminal behavior. But there are two main problems with this. One, Heller made clear that history and not modern-day social science controls the scope of the Second Amendment. In Heller, D.C. argued that handguns were used in the overwhelming majority of gun crimes, but that could not overcome the historical right to possess commonly owned firearms. Two, even if 18 to 21-year-olds are disproportionately likely to commit certain crimes, the individual members of that group are overwhelmingly unlikely to commit violent crimes. Well under 1% a year are arrested for violent crimes. As the Supreme Court held in Craig versus Boren, dealing with sex-based age discrimination and the purchase of alcohol, when constitutional rights are at stake, we do not shackle the rights of the many for the sins of the very few. And in any event, government statistics show that 21 to 25-year-olds are arrested for violent crime at a similar or higher rate than 18 to 21-year-olds, undermining drawing the line at this age in any event. Now that I've sketched out the arguments, I will move to the cases. There are two principal areas where the rights of 18 to 21-year-olds are being litigated: restrictions on 18 to 21-year-olds acquiring firearms and restrictions on 18 to 21-year-olds carrying firearms. There currently is a circuit split on the constitutionality of the federal ban on 18 to 21-year-olds purchasing handguns from licensed dealers. To be clear, this law bars individuals between the age of 18 and 21 from buying handguns from FFLs, but leaves them free to acquire them from other sources. This law makes absolutely no sense on its own terms. The legislative history indicates that it was meant to curtail the clandestine acquisition of firearms, and yet it positively promotes clandestine acquisition by driving 18 to 21-year-olds out of the regulated market for handguns and requisite background checks and into the unregulated secondary market. A panel of the Fifth Circuit upheld this ban in 2012 in a case brought by the NRA, and the full court denied review by one vote, with Judge Jones writing a powerful dissent for herself and 5 other judges. In July of this year, a panel of the Fourth Circuit struck down the ban in a case called Hirschfeld versus BATFE. The opinion is written by Judge Richardson, and I commend it to you heartily. In my view, it is one of the best Court of Appeals Second Amendment opinions we have seen since Heller. The future of Hirschfeld is uncertain, however. While the government can be expected to seek review by the full Fourth Circuit, court filings indicate that the youngest plaintiff turned 21 in July of this year, and there is no organizational plaintiff. The plaintiffs are trying to add a younger individual and an FFL to the case, but it is not clear whether the court will allow that or whether it will instead find the case to be moot. Meanwhile, we are litigating another case challenging the handgun purchase ban in district court in the Fifth Circuit. While our broad claim is controlled in trial court by the NRA case, we have added a twist, an alternative as-applied claim on behalf of 18 to 20-year-old women. Whatever the public safety rationale for barring 18 to 20-year-olds from purchasing handguns generally, it does not apply to 18 to 21-year-old women. They are an extremely law-abiding group, and women are disproportionately likely to be victims of violent crime. Restricting their access to handguns is a perverse policy, and we are looking forward to continuing litigation on this claim. Some states have gone beyond the federal government and restricted the right of 18 to 21-year-olds to purchase long guns in addition to handguns. California and Florida are 2 such states, and there is pending litigation challenging those laws. The California ban is in the Ninth Circuit on review of a denial of a motion for a preliminary injunction. Oral argument was held in May before a panel of Judges Nelson, Lee, and Stein, a district court judge sitting by designation. A decision could be released at any time. The case is Jones versus Bonta. The Northern District of Florida recently upheld Florida's ban in NRA versus Swearingen, and the NRA has appealed to the 11th Circuit. In addition to purchase restrictions, there also is litigation on restrictions on 18 to 21-year-olds carrying firearms. We currently are litigating a case in the Third Circuit, Lara versus Commissioner of State Police, challenging Pennsylvania's carry ban. Like the federal handgun purchase ban, this is a law that is very difficult to understand as a practical matter. Open carry generally is allowed in Pennsylvania outside of Philadelphia, so despite the fact that 18 to 21-year-olds are not eligible for carry permits, they generally can open carry. But open carry rights for all citizens are taken away during a declared emergency, and Pennsylvania has been under declared state of emergency due to the opioid crisis since 2018. The effect of this is that 18 to 20-year-olds are flatly banned from carrying handguns in public, despite them typically being able to open carry lawfully, even without a license. The district court upheld the ban, and we currently are briefing the appeal in the Third Circuit. In addition to the Lara case, we have cases in district court in Illinois, Georgia, and Minnesota, challenging those states' 21-year-old age limit for carry licenses. We are challenging those laws generally, as well as applied to 18 to 21-year-old women. Thank you for your attention today of what is an important and fast-evolving area of Second Amendment law.
Hello there. I'm attorney Ray DiGiuseppe. I'm a former prosecutor, having previously worked as Deputy Attorney General for the California Attorney General's office in San Diego. Since leaving the Attorney General's office in 2010 and moving back east, I've been primarily handling complex litigation matters in jurisdictions across the country at the trial and appellate levels. Much of that work in recent years has involved firearms rights litigation matters for the Second Amendment Foundation, Firearms Policy Coalition, Firearms Policy Foundation, and other firearms rights organizations. I was fortunate enough to participate as a speaker at last year's Gun Rights Policy Conference. I'm glad to be here again. This year, I've been asked to speak on the implications of COVID-19 and what I see as the most important Second Amendment case currently on review. I'll start by asking you to imagine a world where the government could require that people who wish to gather with others outside their home in the practice of their religious beliefs must demonstrate a special need to do so. Something more than the general desire of the average Protestant, Catholic, Jewish, or Muslim person to congregate with like-minded people in the traditional celebration of their faith. And in this world, it's some local government official who gets to declare, without any clear or consistent standards, just based on the official's personal views, whether the need is strong enough to allow the congregation. In other words, the government could police the exercise of religion in houses of worship by blocking people from going to church on the basis that they haven't sufficiently justified the need for religious congregations. Or let's say the government could just block you from attending traditional religious gatherings regardless of any special needs you may be able to demonstrate, supposedly because it's necessary to stop the spread of an infectious disease, but with no exception for those willing to follow standard infectious disease control protocols, while at the same time allowing all sorts of secular activities involving large indoor congregations to continue, so long as they followed such protocols. It sounds far-fetched in the United States, right? Well, without the intervention of the courts pushing back against government executives at the local and state level, not really in this day and age. Over the last 18 months or so, we have seen many instances of states, counties, and cities acting through their executive heads to infringe on all manner of individual freedoms in the name of controlling COVID-19 and its variants. In fact, just a few months ago, California was enforcing restrictions against religious congregations outside the home, barring people from gathering as they traditionally would in celebration of their faith, as a supposed COVID-19 prevention measure, with no exception for gatherings that included face masks or social distancing, but while at the same time allowing numerous secular activities like movie-going and sporting activities to continue with the use of such protocols. This was the Tandem versus Newsom case. The United States Supreme Court intervened there when the Ninth Circuit refused to help, and it declared the obvious, that because California had created myriad exceptions and accommodations for secular activities, its targeting of religious congregations was subject to strict scrutiny, requiring the state to prove that it was furthering interests of the highest order by means narrowly tailored to pursue those interests. Consequently, as the per curiam opinion explained, quote, where the government permits other activities to proceed with precautions, it must show that the religious exercise at issue is more dangerous than those activities, even when the same precautions are applied. Otherwise, precautions that suffice for other activities suffice for religious exercise too, end quote. Because California could not meet this standard, its restrictions infringed the free exercise clause of the First Amendment and were subject to a preliminary injunction. The courts have been similarly protective of free exercise and association rights as well as due process rights in challenges to governmental restrictions on fundamental liberties in other cases, including even more recently where a majority of a panel of the Ninth Circuit, no less, reversed a district court's order dismissing a substantive due process challenge brought by a group of parents against California's public health orders, which forced the shutdown of the private schools where the parents wanted to send their children. This was the Bracht versus Newsom case. The majority there held that under strict scrutiny, just, quote, as with its rigidly overbroad approach to religious services, California once again failed to explain why it cannot address its legitimate concerns with rules short of a total ban. So with that in mind, how can we ensure a similar level of protections and respect for the fundamental right to keep and bear arms under the Second Amendment, generally and specifically in this era of the seemingly never-ending public health concerns being invoked to justify restraints on personal liberties? If our ongoing litigation is any indication, it's not going to be easy and will probably be impossible without the intervention of the United States Supreme Court. We have 3 cases on appeal right now up before the Ninth Circuit, which specifically involve challenges to public health orders issued by various counties in California, which previously shut down the firearms industry in those counties, based on the claim that it was necessary to completely shutter all retailers and ranges to control the spread of COVID-19. Even, however, while allowing numerous other industries and activities to continue, with safety protocols that the firearms industry could have just as easily implemented if they were given the opportunity to do so. These are the Brandy, McDougal, and Altman cases. We obviously got no help at the district court level, which the courts there booted the cases as supposedly failing to state any kind of cognizable claim for relief under bastardized Second Amendment analyses that ignored not only the dictates of Heller, but other long-settled principles of constitutional law that compelled the conclusions these judges were unable or unwilling to reach. are obviously looking for better results on appeal, if not in the Ninth Circuit, then beyond in the Supreme Court. Fortunately, the legal landscape has become less hostile since the time those district court opinions issued, as the Supremes have reined in some of the more far-reaching power grabs by states, with opinions that make clear the government cannot simply place a moratorium on the exercise of fundamental civil liberties in the name of regulating public health. That's much better than where we were a year ago, when many lower courts were acting like the government's power to regulate in the name of COVID-19 was essentially unbridled. More generally, our chances of getting the Second Amendment rights on the same footing with the other enumerated constitutional rights largely rest with the case that the Supremes have already agreed to hear and decide, New York State Rifle and Pistol Association versus Corlett, which is shaping up to be the most significant Second Amendment case of the year, and perhaps the most significant since Heller. This case involves the constitutionality of the New York law that bans all open carry and only allows concealed carry upon demonstration of a special need for self-protection. That is, something more than a general desire to carry a concealed weapon to protect one's person or property. That question inevitably puts before the court many of the core underpinnings of the analytical frameworks that lower courts have been applying for years now and treating the Second Amendment as a second-class right, one worthy of less protection and subject to greater governmental restriction than other rights. As the plaintiffs contended in their petition for certiorari in that case, quote, the refusal of some lower courts to meaningfully engage in the textual and historical analysis that Heller requires is not confined to cases involving the right to bear arms outside the home. Time and again, courts have effectively replaced Heller's textually and historically grounded analysis with a loose form of interest balancing in which the state always wins. Repetition of an error does not cure the error, it just heightens the need for the court's review. End quote. Well, the plaintiff's petition for cert was granted, so let's hope that means at least a majority of the Supreme Court will agree. In all events, though, as the plaintiffs explain in that case, regimes like this purport to, quote, ration constitutional rights instead of protecting them, when government may not reserve to a select few what the Constitution guarantees to all, end quote. That is what we must continue to press in pushing back against efforts by the government to trample on the Second Amendment throughout this pandemic and beyond, as that is the only way to ensure this right is placed back on equal footing with the other enumerated constitutional rights, like the free speech and association rights, which are much more readily recognized and respected in our system. And that is the only way to ensure that this right is treated as the fundamental civil liberty that it is. Thank you for your time.
Hi, I'm Mark Smith from the King's College in New York City. In this era of defunding police departments and reimagining policing, the idea that each of us is our own first responder has really taken on greater significance than ever before. Now, some folks, our neighbors, are beginning to understand, I think, for the first time, that the police simply cannot be at all places at all times, and that you alone are responsible for protecting your life and the lives of your family. But the idea that you and I are our own first responders is actually not a new concept in American life. And I want to talk about that today. So today, what I'd like to do is to focus our attention on the founding period of America, that period what I call 1760 to 1826, which is the year that John Adams and Thomas Jefferson both passed away, 1826. And I think this is highly relevant to the Supreme Court's interpretation of what the Second Amendment means. Back then, at the founding era, early Americans were really primarily responsible for not only protecting themselves, but for protecting crime in the community. So I want to take a trip back in time to this colonial period. Now, it might surprise you to learn that colonial America was actually quite violent. Colonists faced a number of threats that necessitated carrying firearms separate and apart from the threats they faced from foreign invasions, let's say, or from tyrannical rulers with the name George. Former Supreme Court Justice Anthony Kennedy said during the oral arguments in the landmark Heller case that the colonial settler had to defend himself and his family against hostile Indian tribes, in addition to outlaws, wolves, and bears, and grizzlies, and other things along those lines. Now, the first of the founding era violent threats I want to discuss is the day-to-day violence that fellow citizens could experience from their other fellow citizens. Criminals, of course, are not new. They've been around forever, and they were around in the founding period. And firearms were needed outside the home to defend against attacks by violent criminals. Remember, there was no police force at this time. So you, again, like today, were your own first responder. In fact, if you think about it, there was really no shortage of criminals in the New World. Two simple examples. Remember, the state of Georgia, believe it or not, was initially conceived of as a penal colony. It was actually going to be for criminals. Although I think that plan was ultimately scrapped, it just goes to show you how people thought about North America in the colonial times. Now, in the 18th century, Great Britain exported an estimated 50,000, maybe even more, convicted criminals to America. We always think of Great Britain exporting felons and criminals to Australia, but they did the same thing to the United States as well, before it was the United States, of course. So these people were in and amongst us at the founding periods. And, criminals in Britain, in England, guess what? Acted like criminals here too. Just a couple of examples out there that you can look up. In the late 18th century, the New Jersey coastal area was known as the Pine Lands, and that was infested, believe it or not, with robbers who in the dead of night would go around and plunder, burn, and murder, just like criminals are wont to do. The inhabitants were in constant terror, according to reports. They were obliged for their safety to carry muskets with them into the fields and even into houses of worship or, of course, churches. In the area of Kentucky and Tennessee, you had a group of people known as the Hart Brothers. And people report from the period of 1789 to 1799, there's probably 20 to 38 victims of these violent Hart Brothers in Kentucky and Tennessee. Again, not your friendly neighbor types. And you needed a gun to protect yourself against people like the Hart Brothers and others. Bear in mind that early American urban areas, cities, were really not any more civilized. If you think about Philadelphia, right, the nation's original capital, Philadelphia's homicide rate for the time period of 1720 through 1780 was actually 2.5 times that of the homicide rate of London during that same period. A leading study of historical time records actually concluded, believe it or not, that throughout most of the 17th century, the peacetime murder rate for adult colonists ranged between 100 to 500, maybe even more each year for every 100,000 adults in the then United States, before it was called the United States. Now that is actually 10 to 50 times greater than the rate in the United States in the year 2009. So these were pretty violent times. Now, this leads me to the next violent threats that faced the founding generation, and that's mob violence and riots. I think you're going to be hearing a lot more about mob violence and riots in the future and how to respond to them and the role of the Second Amendment in doing it. But I don't think we have to belabor the point today. I think we could just simply say that back in the colonial period, the founding period of the country, mob violence and riots were a real fact of life. I'll just give you two examples. The famous example was, and I'm sure many of you are familiar with this, with the Stamp Act's passage in 1765, that caused a whole series of riots. In fact, in August of 1765, as most of you know, a mob pillaged and ransacked the home of Thomas Hutchinson, who was the lieutenant governor of Massachusetts at the time. That was a big deal. And then later that year, in 1765 in Philadelphia, there were stories that maybe even Ben Franklin, that's right, the Ben Franklin, who at the time was hanging out in London, might have supported the Stamp Act. Well, people didn't like this rumor, and they didn't like the idea of Ben Franklin maybe doing this. So in September of that year, 1765, guess what happened? A mob sought out to destroy the home of Benjamin Franklin. Well, Benjamin Franklin's wife, in a famous story, asked her cousin to show up with a group of armed men to confront this mob. And guess what happened? Those armed men caused the mob to disperse and saved Benjamin Franklin and his wife's home. Very famous story that you all should be familiar with. So now we've talked about the dangers of domestic criminals as well as mob violence at the time of the founding. But let's talk about probably the scariest threat that the colonists faced, and that was the conflict with, as Justice Kennedy would say, the Indians, or we might say the Native Americans today. Now, it's really difficult, I think, for modern Americans who are familiar with the Disney-fied version of Indians to appreciate the acute, terrifying fear that Indian raids held on the American psyche at the time. You know, as the American settlers continued to press westward and expand their hold on the Western Hemisphere and in North America, you got more and more clashes with the Native American population. In fact, James Madison, the author of the U.S. Constitution, actually wrote about attacking Indians in one case that they were, quote, determined in the extirpation of the inhabitants. Strong language there. Moreover, the tensions between the settlers and the native peoples are constantly inflamed by virtue of the power struggles between the European powers, whether it be the Spanish or the French or the British. We're all enlisting the support of various tribes in the struggle for who would control North America and all of its riches. As previously noted, Justice Anthony Kennedy of the Supreme Court actually recognized the real dangers in which colonial Americans lived from Indians. And there's no surprise there, because if you look at your history books, it's all over the place that the tensions between the European colonists and the native people started very early. The late famous Pulitzer Prize-winning historian from Harvard, Bernard Bailyn, actually vividly recounts a series of surprise attacks in 1622 near the Jamestown settlement. Professor Bailyn wrote, quote, in plantation after plantation, the Indians turned on their unsuspecting hosts, in some places while sharing breakfast with the people at their table, and with axes, hammers, shovels, tools, and knives slaughtered them indiscriminately, not sparing either age or sex, man, woman, or child, so deign in their cruel execution that few or none discerned the weapon or blow that brought them to destruction. Strong words by Bernard Bailyn. Continued westward expansion by the colonists, of course, continued to cause tension with the Native Americans. And of course, the most famous reference to the dangers and concerns of the Native American population by the colonists was in the actual Declaration of Independence. In fact, in the section labeled the abuses and usurpations charged against King George III in the Declaration itself, they included the language that the Crown had, quote, endeavored to bring on the inhabitants of our frontiers, the merciless Indian savages, whose known rule of warfare is an undistinguished destruction of all ages, sexes, and conditions. So the fear of Indians made it into the Declaration of Independence. Now, beyond that, we have to know one other thing. In addition to domestic criminals, mob violence, and the threat of Indian attack, there was one other constant threat that the American colonists were aware of that necessitated the citizen to be armed and ready to defend themselves, their country, their family, and their friends from violence. And that is the constant threat of foreign invasion and war. Just to name a couple of the wars that occurred during kind of the founding era or a little bit before that, which would have caused an impact on the psyche of colonists. You had King William's War in the late 17th century. You had Queen Anne's War in the early 18th century. These were just wars between European powers that spilled out over into the United States. And of course, you had the French and Indian War, where George Washington got his start in the military, the Revolutionary War itself, and the quasi-war with France in 1798 through 1800, in addition to, of course, the War of 1812. All of these illustrate the point that the founding period of the United States was dangerous and violent and required arms in the hands of civilians for self-defense. So now, of course, it is important for all of us to understand and to remember that colonial citizens could not just pick up the phone and call 911 when they faced violent threats. Even if they had the means of communication, there was really little semblance of organized law enforcement back then. Modern organized police forces did not begin to appear until the mid to late 19th century. So early Americans were really, again, their own first responder. Now, the founders understood that even if the written Constitution delivered the benefits they hoped for, well, guess what? Humans are humans, and civilization, frankly, is very fragile, and the veneer of civilization is thin. The founders understood this, and I think after what happened in the summer of 2020, we must recognize this is really the case. Indeed, keep in mind that one of the main points of the founding documents, the Constitution, was to try to create a system of checks and balances, which included the Second Amendment's right to keep and bear arms, to try to protect our liberty against those who would encroach on our lives, our property, our liberty, our freedom, and the like. Before I conclude, I want to mention two excellent sources for more information and details about some of the examples and discussions I talked about today in this presentation. The first is I think you should check out this book by historian and attorney Stephen Halbrook, which is the most comprehensive history of the right to bear arms outside of the home. And the title of this book is The Right to Bear Arms, the Right of the People or the Privilege of the Ruling Class. It is great, and it is full of historical examples, including some of the examples that I referenced here today. The other source that I think was a great source was an amicus curiae brief submitted in the New York State Rifle and Pistol Association versus Bruin case. And that was a brief submitted by a group called the Citizens Committee for the Right to Keep and Bear Arms. It was a great brief. It really talked about the violence during the founding period. And again, I would urge you, if you are doing research in this area or want to learn more, check out that brief in addition to attorney Stephen Halbrook's book. So to conclude, colonial America was an extremely violent place as colonists faced threats from many different sources. Murder was common, politics was frequently practiced through mob violence, and there was always this sort of pervasive fear of possible Indian raids in the community. So as history teaches, the colonists understood that you as Americans are always your own first responder, even if the police are there or not. You have to realize that no one cares more about your life than you do. So now, as the Supreme Court is preparing to hear the Bruin case, which will decide whether you have a right to keep and bear arms outside the home, I think based on the history that I've recounted today, the answer is unequivocally yes. You should have a right to bear arms outside the home, and it's very important that you be prepared to do so to protect yourself, your family, your friends, and your community from violence that may unlawfully come your way. Thank you very much.